a text to the Attorney General?
We did, yes, sir.
What day was that sent?
That was the next day.
What next day?
Well, the October 1st.
Okay, October 1st.
Yes, sir.
And then you resigned October 2nd.
That's correct, sir.
All right, just so I can get it in my mind. You learned about the subpoena on the 29th of September.
Yes.
Y'all met the same day.
Yes.
You went to the FBI the next day.
Yes.
You sent a text on October 1st the next day.
That's correct.
And you also signed, all of you signed a letter, correct?
Correct.
And then the next day you resigned.
Yes.
Okay. So, just so in case the jurors are wondering about the timeline, and maybe they'll wonder, go back, Eric, if you would. Your Honor, one thing I want to mention. Eric, would you stand up? You hear me say Eric. Your Honor, this is Eric Arroyo. He's our audiovisual guy that works at our office. In case you were wondering who I was yelling at over there. All right, Eric, would you, AG Exhibit 170, go to Brickman 187. And let's just try to confirm in our minds that the documents match up to the timeline. Page 187. Okay, here we are, and I think everybody can see this. We have a major problem. The kid has served a subpoena on a bank, showed up there in person at the bank with someone from World Class. I need you guys to come back. You wrote that in text, true?
Yes, sir.
And that was on the 29th, right?
That's on the 29th, yes.
Okay. The next day, you went to the FBI, September 30th, true?
That's true, yes, sir.
And the next day, October 1st, you sent General Paxton a text.
Yes.
Let's look at AG Exhibit 127, Exhibit 31. Okay, here's the text. This is the text. You deleted this text, right?
I had received a copy of it from Miss Mace.
Okay. And this is the text you sent the general?
Yes, sir.
On October 1?
Yes, sir.
Okay, and then the group of you folks then signed a letter, is that right, on the same day?
Yes, sir.
Let's go, Eric, if you would. Same exhibit, Exhibit 1. We're looking at Exhibit 127, Exhibit 1. Very tedious, but we got to look at this. We really need to break these out so this doesn't take this kind of time. Okay, here we are. This is the letter that the 1, 2, 3, 4, 5, 6, 7 of you signed, right?
Yes, sir.
And that was on October the 1st, true?
That is true, sir.
Okay. Let's take a look. Keep that October 1, 2020 date in your mind. Can you do that for me?
I'll try, sir.
Okay, let's look at AG Exhibit 434. You see that? That's the bar record of George P. Bush. You see that?
I see what the document is. I think everybody can.
Now look at the bottom. Look at the bottom entry. His law license was inactive for 10 years. See that? Look at when he requested to reactivate his license. Tell us all that date.
Where, you want to point it to me?
10/1/2020. Do you see that?
I see the document says that, sir.
What date is it? When he applied to activate his license.
It says October 1st, 2020.
Let me get this right in my mind. On October 1st, 2020, you sent the general a text that we saw, right?
I did, yes, sir.
On that same day, you signed a letter, 7 of you, right?
Yes, sir.
And coincidentally, on that same day, George P. Bush, who ran against General Paxton, did he not?
He did in the primary.
George P. Bush applies to reactivate his law license. You see that?
That's what that document appears to say.
You ever hear that old saying, there are no coincidences in Austin?
Actually, I don't.
I'm
not an Austin guy, so no, I haven't heard that one.
There are no coincidences in Austin. You never heard that?
No, I haven't.
Okay. Now I'm trying to figure out the connection here. Before October 1st, you had already talked to Johnny Sutton, hadn't you?
I had not.
Somebody had, right?
I believe so.
Somebody within these 7 people had, right?
I believe so.
And what's Johnny Sutton's relationship with George P. Bush?
I have no idea.
Don't know.
Any. I have no idea if there's any.
No clue.
No.
So the day after George P. Bush applies to reactivate his license, you resign. Is that right?
I resigned on October 2nd, sir.
Let's look at that. That is House Manager Exhibit 291. Bring that up on the screen, please. House Manager Exhibit 291. Second page, please. That's your resignation letter?
Yes, sir.
Okay. Now, you told us before you resigned, you talked to people at the governor's office?
Yes,
Who?
Your Honor, is he going to offer it? Because this is not in evidence,
Which one?
the exhibit you just put up.
House Manager Exhibit 291, to the extent it's not in evidence, I move for admission.
It's admitted.
Thank you.
Now, let's get back to the subject at hand. Who at the governor's office did you speak to before you resigned?
well, a couple of days before, we met with, I believe it was Jeff Oldham, who would have been, at that time, the governor's general counsel. I believe James Sullivan, who was at that time deputy general counsel. And I believe the chief of staff, Louis Sines, was in the meeting as well.
Was anyone else in the meeting?
Other than myself, and I believe Mr. Bangert and Mr. Brickman. I believe that's all.
Did you talk to Mr. Hodge?
No, he wouldn't have been in that meeting. He wasn't at the governor's office at that time.
Right. Did any of you, the group that you know of, talk to Mr. Hodge?
Not that I'm aware of.
You know who I'm talking about, don't you?
I know who Daniel Hodge is. Yeah, he was at one time the governor's chief of staff, but by this time, Louis Sines was chief
Right.
of staff.
Daniel Hodge is a lobbyist?
That's my understanding.
Sure. Why did y'all refer to yourselves as the Cool Kids Club?
I don't recognize that.
You don't recognize it?
I don't.
Okay. Go back, Eric, to AG Exhibit 170. Your testimony is that you folks, you 8 folks, never referred to yourselves as the Cool Kids Club?
My testimony is I don't recall me ever using that phrase.
Okay, how about the others?
Sitting here right now, no.
Okay. Do you recall ever being sent a text like getting fired will make you a cool kid? Eric, go to Brinkman 203. Brickman 203, and this is exhibit. Okay, do you see the text there I'm referring to? Being fired will make you a cool kid.
Mr. Busby, I see that, but I don't know if am I on that exchange? The message at the top, if someone could highlight that. I do have my glasses on, but I'm trying to see it. Yeah, I don't see my name there. I don't think I was on that exchange,
Don't think
sir. No, after I left, I don't think so.
Now, when did you find out about the second referral? When did you finally find out that, you know what, when I went to the FBI and I was telling them that this guy was subpoenaing documents that had nothing to do with the referral, when did you find out that the documents that were being subpoenaed actually had everything to do with the second referral? When did you find that out?
Mr. Busby, sitting here today, I don't recall when.
Okay, let's look at same exhibit, Brickman 202. Y'all read about it in the news, didn't you?
Well, again, sir, I don't think I'm on this text message.
Okay, but just look at the text message I'm referring to. This is about alleged second complaint. Interesting. You see that language?
Could you highlight it for me, please?
Eric could. See that language? They're referring to a news article, and they're, for the first time, learning that, in fact, Mr. Kamek had been sent a second referral directly from the DA's office, and that's what the subpoena regarded. Is that about the time you learned about this?
Again, I don't have a memory of learning it from that.
I mean, you guys were alarmed, you said. I think the word you used was, we were alarmed that this kid, as you called him, had sent a subpoena to a bank, and you believe that subpoena had nothing whatsoever to do with whether the FBI had violated Mr. Paul's rights.
Do you have the second referral?
You're going to see it in a minute.
What did it relate to? That may help me.
Just a second. I'm going to help you. Don't worry. I'm not going to.
No, my objection is, Your Honor, he's twice, maybe 7 times, I've resisted objecting because the witness, quite frankly, is handling him so well. However, he's now cross-examined him about an email that he's not, or text messages he's not on. He doesn't know anything about. Now he's going to cross-examine him about a second referral, which the testimony is clear he never saw and doesn't know. He's therefore asking, give it to me, and before you ask me questions about it. So I object to him being asked about documents he knows not only nothing about, but is not part of.
I'm trying to find out what was in his mind when he resigned and when he went to the FBI about what he didn't know. And I'm asking him about why the alarm. And the alarm is, Your Honor, I think he's told us that he didn't know about the second referral. And I'm trying to figure out when he learned about it.
I think the law is clear. He shouldn't be questioned about documents that he has not seen in this situation, knows nothing about. I mean, he just said, I never saw the second referral. I don't know anything about it. And now he wants to sort of lead him through, as he gets to do on cross, about things having to do with documents he hasn't seen. So I object to that being inappropriate.
Sustained.
And that's the whole point. You didn't know about the second referral, did you?
I did not.
Right. And so you went to the FBI thinking this kid, as you called him, should not be subpoenaing banks, right?
I did think that.
But you now know that if he was charged by the DA's office of Travis County to investigate bid rigging that would be, in fact, something that he might subpoena, right?
I actually don't know that.
You don't know.
I do not know that.
And since we're on the subject, let's look at, because you know now there were 2 referrals, right? You know that.
I think I know that because I've reviewed the internal report at one time.
Okay. Let's look at the first referral. The first referral is, you're going to have to get into Exhibit 127, Exhibit 3, as quickly as we can. This document is in evidence. I'd ask you to take a look at it once Eric gets it on our screen. Exhibit 3, Eric, page 3. All right, can you see that, sir? He's going to try to bring it up. Page 3, Eric. Bring it up so you can see it. You certainly were aware of this first referral from the Travis County DA's office, correct?
At one time, I became aware of it, yes, sir.
And this was something that Maxwell, Mr. Maxwell, and Mr. Penley were supposed to be handling, true?
That is true.
And Mr. Paxton, the general, did not believe that Mr. Penley was pursuing this matter appropriately. Isn't that true?
He expressed that at some time, yes.
He felt like that Penley, who was a former assistant U.S. attorney, and Maxwell, who was a former Texas Ranger, were not taking the referral seriously. Isn't that true?
I don't know if I'd say it that way.
Let me ask you this. If you don't take a referral seriously, one thing you might do is not even log it into the system, right?
I don't know if I would characterize it the way you have.
Who would be responsible when a referral is made from the Office of District Attorney, Travis County, to the Attorney General's office to log that referral and open the investigation? Who would be responsible to do that?
I mean, somebody in the division.
Whose division?
Well, it would either be law enforcement or criminal justice. This would be one that sort of both had concurrent.
So ultimately, Mr. Penley or Mr. Maxwell?
No, they were in charge of both of those divisions, respectively.
Let's look at Exhibit 5 to Exhibit 127. Did you realize that neither Maxwell nor Penley ever even bothered to open an investigation when they received the referral?
The document you're showing me, I don't see my name on.
We were not able to locate this referral in any of our databases. I want you to tell me, as the first assistant who's responsible for the day-to-day operations of the AG's office, how could it possibly be that when the Travis County DA's office feels like the people they would typically refer this to, that is, maybe the FBI, maybe the Texas Rangers, but she felt that they were conflicted, and so she sends this to the AG's office, why would it possibly be that you guys wouldn't even log it into the system? Help me understand how that possibly could happen.
I would have to ask Mr. Penley or Mr. Maxwell.
I will do that. Weren't you ultimately responsible for making sure that your people did their jobs?
I mean, ultimately, but as I've testified, Mr. Busby, and I'm sure you're aware, it's a large office with a lot of matters, and I entrusted, in this case, Mr. Penley and Mr. Maxwell.
Now, couldn't you see how maybe your boss might be frustrated, who felt, he felt like he was targeted by the feds, right? He expressed that to you before, right?
Is he soliciting hearsay now after all these objections?
Do you have an objection? Are you asking a question, or do you have an objection?
I have both. A question on the lead into an objection is, he's asking for hearsay. I guess it must be a valid objection. He made it 30 times when I was talking.
I don't know what that objection is, but I'm entitled to ask the man what he's told us multiple times about how Ken Paxton felt about this, that, and the other, and he knows how Ken Paxton feels about the feds. And that's what I'm asking.
Let's just move on, gentlemen.
Tell us how Ken Paxton felt about the feds.
I mean, he did have some distrust of the feds. His primary distrust was the state officials.
So can you understand why your boss might be frustrated with his two top lieutenants when they weren't doing their jobs and investigating the referral from the Travis County DA's office?
I wouldn't characterize that as that, Mr. Busby, at all.
And of course, when you talk about conflicts, I mean, they decided we're not going to send it to the Rangers and we're not going to send it to the FBI. But we know that Mr. Penley was a former with the feds, right?
Mr. Penley was an assistant U.S. attorney for many years
And
in Dallas.
Right. And Mr. Maxwell also had a past history, did he not?
He did, and Mr. Paxton promoted him to the position that he held before I got there.
Now, you told us that you knew General Paxton was frustrated that neither Maxwell or Penley would investigate the referral, right?
Actually, I said I couldn't agree with you.
And so Mr. Paxton, General Paxton, wanted an outside party to do it, right?
We discussed that.
And more than one person was considered, isn't that right?
That is correct.
One of the people considered was a man named Joe Brown.
Yes.
You liked Joe, didn't you?
I've known Joe for years.
I mean, you liked him.
I've known him for years, and yes, I had a favorable view of him. Yes, sir.
Another one considered was a man by the name of Strickland.
Cliff Strickland considered, his name came up, yes.
His name came up, and then they figured out that Cliff Strickland was no way going to work for $300 an hour, right?
I believe that's true, yeah.
So instead, they settled in on a guy who was young, but all he had to do was investigate. They settled in on Kamek, right?
Well, eventually, that's apparently what the Attorney General did, yes.
And you actually, even though you claim it wasn't an interview, you spent 15 minutes with Mr. Kamek, did you not?
I spent 15 minutes with Mr. Kamek.
Because we know from the visitor logs, Exhibit 127, Exhibit 6, please put on the screen. We know from the visitor logs, we're going to have to figure out a way to break these out, Eric, so this doesn't take so much time. We know from the logs, Joseph Brown came to the office on August 27, 2020 at 3:45 and spent 2 hours there, right?
If they can he enlarge that, sir?
Eric, see there at the bottom on Joe Brown, it shows when he came in and when he left. Checked in, checked out. Bring that up. Can you see that?
I guess.
And
I'm not
sorry.
familiar with this document, but
I'm sorry.
yeah.
May I approach the witness, Your Honor?
Yeah, maybe it's easier.
I'll show you the same exhibit.
Just wait to go to the mic to speak to him, though. Okay, thank you.
Confirm for me and the members of this jury that Joe Brown on August 27, 2020 spent 2 hours in the AG's office.
I can confirm to you that this document says checked in August 27th, 2020 at 3:45 p.m. And then it says checked out Thursday, August 27, 2020 at 5:45 p.m. And
So
Joe Brown's name is at the top. I'm sorry, sir.
That's all
Joseph
right.
Brown's name is at the top.
Right, that's a visitor log. That's how we know who comes in the office and who leaves the office, right?
I mean, I'll assume that that is true. but I don't know if I've ever seen one of these before.
And let's look at the next page. Here's the visitor log for Brandon Kamick. Do you see that?
I do, sir.
Go to the bottom, Eric. Even I'm having trouble reading that, but it looks like...
What?
Why don't you tell us what it says? It
Well,
says...
it's cut off on this copy, but it does say August 26, 2020, 3:08 p.m. It says KEDN. We can assume that's checked in. And then it says KED out August 26, 2020 at 4:38.
So would he stay an hour and a half or more in the office?
That's what this document says, yes,
So
sir.
he came in on the 26th, that is Mr. Kamick, stayed an hour and a half, and then Mr. Brown came in the next day and stayed 2 hours. Is that true?
That is correct.
Okay. May I approach the witness? And we know, because we have your daily calendar, that you listed in your calendar times and you were considering. You mentioned Cliff Strickland, you mentioned Joe Brown, right?
I did.
If this was so illegal and so out of bounds and so egregious, why the devil are you meeting with these people?
I don't understand the question,
I'm trying to figure out why, if you thought, hey, Penley's doing his job, the former AUSA is investigating the feds, the former Texas Ranger is investigating the feds or the magistrates or the DPS, why would you be meeting with several lawyers as outside counsel to do the very same job?
Well, it wasn't to do the very same job.
Well, help me understand then why you met with Joe Brown. Why did you think it was just a pleasure call?
No.
Just showed up for 2 hours for no reason?
No, I'm not saying that, sir.
Okay, you knew why he was there. You knew he was being considered for outside counsel to take over the job that Penley wasn't doing, didn't you?
No.
We know from your logs is this Exhibit 127? You didn't put a label on it, the logs. Pull up 127, please. One moment, Your Honor. All right, are this your daily calendar?
It's my physical daily calendar, yes.
This is what you keep on your desk to make notes, like here's what I want to accomplish today and some notes about what you do?
Yeah, yes, sir.
Okay, let's go. We're looking at Board of Managers 558, and Eric, if you don't mind, turn to page 98. It's bait stamped there at the bottom. We see a name on that document, do we not? You see the name Cliff Strickland?
Yeah, I see a couple names, but I do see Cliff Strickland, yes.
Okay, can you tell us all why you wrote Cliff Strickland's name in your daily calendar?
My guess is General Paxton mentioned him. I know who that is. I knew his father. I know his father.
Sure, and you were supposed to check him out, see what his hourly rate was?
I don't know if that's true. I think I don't know.
I don't know.
No, I don't know.
Right. But you do know his hourly rate's $800, don't you?
I'm not surprised that it's 800, but I don't know if I know that.
Yeah. That's too expensive for outside counsel, is it not?
I would think it's
Yeah, I mean, even if, we have some world-class, probably the world-class lawyers here, they're only getting paid $500 an hour.
Yeah.
You knew that.
Yeah. What's your rate?
Huh?
What's your rate?
Well, you'll find out soon enough.
Yeah.
So Cliff Strickland was too expensive for the outside counsel gig. True?
What I recall is that Cliff Strickland denied being willing to assist in this matter.
So let's go over to page 100 of the same document. He denied doing the work because he wasn't going to get paid his hourly rate. That's the reason. Is that not right?
Again, Mr. Busby, I don't recall that.
Now let's go over to page 100. You wrote some other notes, but you put, I like Joe. That's Joe Brown, right?
I believe that's so, yeah.
So you had written in your notes Strickland's name, Joe's name. We already know that you met with Kamek for at least 15 minutes, although you've told us all that wasn't really an interview. Why don't you tell us why you're doing this? If you were so adamant we weren't going to use outside counsel and you thought it was wrong and you had all these objections to it. Tell us why you were going through the motions here.
I wasn't going through the motions. If you look at the notes below, sir, after I met with Mr. Brown, I met with Mr. Penley, and you'll see in parentheses it says DM out. That's referring to David Maxwell. The outside counsel we were looking at was to assist Mr. Penley and Mr. Maxwell. That was always my understanding. That was always my expectation.
Right. But see, Mr. Penley and Mr. Maxwell weren't doing anything.
See, I disagree with that, sir.
They didn't even open a file.
They kept asking Mr. Paul and his attorneys for documents, and they wouldn't give them documents.
Did they open a file?
Again, sir, I don't know. I know that they were working on it because at different points in time, they told me they were. They had meetings. They met with Mr. Paul. They met with Mr. Wynn. They kept asking for documents. Mr. Penley repeatedly expressed his frustrations that Mr. Paul and his counsel were not cooperating.
You were so against the idea that you told Mr. Vassar to draft a contract.
I don't believe I did that, sir.
Well, that's what he says.
Well, I don't believe I did that, sir.
Do you know that he drafted a contract for Mr. Brown and for Mr. Kamek?
I know he drafted one for Kamek, because that was later. You showed that to me this morning. I don't know about Mr. Brown.
One of the things an outside counsel has to disclose is whether he or she has conflicts that would prevent them from taking on an outside matter, right?
That is true, sir.
Let's look at Exhibit 127, Exhibit 8. As he's pulling that page up, you also told Vassar, we need to keep this on as short of a leash as possible. We don't want it running away, right?
That doesn't sound like me.
All right, we'll ask Vassar that when
Do you
he
have
shows
that?
up.
That language.
Well, that's what he said in
like,
his interview, but we'll ask him directly.
That language doesn't sound like Jeff Mateer.
So let's look at the correspondence between, now, where in the chain of command, where is Vassar in relation to you?
Let's see, at this time, he is deputy for legal counsel, and he would be a direct report to me. Through assisting me on that would be Mr. Bangert.
Okay, so you would consider him a direct subordinate.
He is a direct subordinate, but specifically on it because Ryan Bangert had been in that position, he worked very closely with him.
So Eric, if you would, in this exhibit, turn to the last page. And we can see Vassar, the email. that he sent an outside counsel contract draft. You see that?
I mean, I don't think I'm on this. I've not seen it before.
I'm asking if you see it now.
We can see it on the screen. Sure. I see it on the screen.
Vassar's your direct subordinate.
Again, through Bangert, yes.
He's sending an outside counsel contract draft.
It says, please see attached.
Yeah. And then in response, Mr. Brown lays out some things that might or might not be conflicts to take on the representation. Do you see that?
Let me read it. Can you make that bigger, sir? Was bigger. What about the first paragraph first? I'm sorry, the first paragraph first, sir. Okay. I see in the first paragraph he talks about malpractice insurance.
Right.
Second paragraph, sir.
You see what the scope of the work is as you're reading that?
I read it, sir, yes.
The scope is that I will fully investigate the circumstances related to the referral received and provide a report related to any potential criminal charges.
That's right. I see what it says, sir.
And let's go to the next page, I should say, Eric. More correspondence between Vassar and Mr. Brown related to the draft. See that?
Now, isn't that the same email we just saw?
Eric, please go to the first page of the email. There you go.
Okay.
Vassar says the malpractice issue may be one that we can resolve. That's referring to the previous email about malpractice insurance, right? See that?
I see that, sir.
Now, my question to you is, did Vassar, your direct subordinate, tell you, you know what, we're looking at Brown, I'm done a draft contract for Brown, but he doesn't have malpractice insurance. Is that a problem? Did he tell you that?
I don't remember that, sir.
Don't remember it?
I do not.
Can we agree, as of September of 2020, that your subordinate had drafted a contract for Joe Brown and was talking through the scope, et cetera, of the representation?
These documents appear to reflect that, sir.
Let's go to Exhibit 7 within 127, Eric. And bring up, Eric, if you would, the email from Mr. Vassar to Mr. Kamek on September 4, 2020. Can you see and confirm, sir, that at the same time that Vassar was sending draft contract, or at around the same time he was sending a draft contract to Mr. Brown, he was doing the same with Mr. Kamek?
I can read the email. I don't think I was copied on the email, so I'm seeing it here for the first time.
And of course, we had already seen from the other email there was a malpractice insurance issue with Mr. Brown, right?
I saw on that Mr. Vassar said it was resolved.
But there was no such issue with Mr. Kamek, was there?
Highlight that, Eric. I'm sorry, Mr. I don't know his last name. I don't see it mentioning malpractice insurance.
Right. So as we looked at these three people, one of them's too expensive, one of them doesn't have malpractice insurance, and the other one's, he's young, but he doesn't really have to do a whole lot. He's just got to do more than Penley, right?
Again, sir, I would not characterize it that way at all.
And let's go to Exhibit 9 within 127. Here, if the jury wants to see the actual contract sent by your subordinate to Mr. Kamek, they can look at this exhibit. You see it there?
What's on the screen right now is a letter. Well, it says Brent Webster at the top.
That's
Who would
because
have
he
been
had to
after
collect
me.
all the emails.
Say that again,
That's
sir.
because he collected all the emails.
Okay, so it says Webster at the top, and it says from Ryan Vassar. It doesn't say who it's to, except it says general.
Right. This was the contract that Vassar wanted to use with both Kamek and Brown, and a copy was provided to the general. Do you see that?
I see what the email says.
Okay. Now, you've told us all that you objected to hiring Kamek, and the reason you objected is because you thought Penley could handle it and said he was handling it, right?
That's part, yes.
And Penley did not want somebody to come in and do it. He said he was going to do it himself, but he was just waiting on documents, right?
That's part, yes.
Okay. And so as the executive approval process went forward, it stopped at Penley, right?
That's my recollection, yes, sir.
Let's look at AG Exhibit 130. And as we're pulling that on the screen, just tell us point blank, how long had Penley been at the office as of this time?
That's a good question, sir.
I hope all of my questions are good.
Some are.
Some, okay. How long had Penley been at the office as of September 2020?
Yeah,
Mere months, right? 8 months at max, right?
I honestly do not have a recollection of when he started. I know when I came in, Adrian McFarland was the deputy. She retired at a point. We recruited. We were looking for the position. Mr. Paxton had known Mark, recommended him highly, and so he became, part of our team. How long? Months? I guess ask Mr. Penley.
I will. What we have on the screen is the executive approval memorandum with regard to the outside counsel contract for Mr. Kamek, right?
Can you jump down to the Ray real? I'm sorry. If you could go down to I see it's the executive approval memo. I see the list of names. Can I see the
synopsis?
The Ray line will help first.
No, Ray, he's asking for the Ray line, please.
Well, I see that. I'm not seeing it on this page.
It's there. Eric, it's in bold. Ray.
Yeah, I see the Ray, but I'm sorry, and I keep going back and forth because I'm trying to look at it. What I'm not seeing is Kamek referenced. If you say the next pages are Kamek, I'm not going to dispute that, obviously. The document speaks for itself.
Sure. Let's look at the people that approved it. Let me ask you this. None of these people can veto the Attorney General, can they?
None of these people can veto the Attorney General, but our processes were in place to protect him and to protect the agency that you had proper sign-offs.
I'm not asking about your processes, your bureaucrat processes. I'm asking about legally. None of these people can veto the Attorney General, can they?
That's a tough question for me to answer.
Why? You should know that, should you not? If you're the first assistant, that's something you should absolutely know by now, right? None of these people have the legal authority to veto the Attorney General. Isn't that true?
I think if the Attorney General is taking an action that is improper, then it's incumbent on the staff, and that's why these processes are in place.
Improper, according to...
So I don't think it's proper, for instance, that Dan Morales goes out and enters into a deal.
I'm not talking about
Greg
Dan
Abbott
Morales.
went out and entered into a deal. The process, it's the agency, and the agency has, I know you're making comments about the process and bureaucratic, and look, it may be, but there's a reason.
It is.
There's a reason. The Attorney General can't on his own go out, because when this legislature, they give authority for the agency to act, right? They give, you can do a certain thing. For instance, in the government code, one of the provisions in the government code, Mr. Busby, I'm sorry.
You're not answering my question.
Well, I am answering your question.
Okay,
One of the, in the government code, the legislature has given the Office of Attorney General the authority to enter into outside counsel contracts. That's authority given. In addition, this legislature gives money so that you have money to actually, so you need money and you need authority. And so when you ask the question, could an attorney general do that? I mean, he needs to have authority and there has to be funds to do it. These processes are in place.
You finished?
I was trying to answer your question.
You're telling the members of this jury, each of them, a senator elected by the people, that a bureaucrat in the office has the authority to veto the boss. That's what you're trying to suggest to us, are you not?
What I'm trying, can I answer your question?
That's
what
why
what I'm trying to suggest to you is this legislature gives authority to the agency. They say what the agency can do. We have the Constitution, we have the statutes. Part of that is also money.
The Attorney General is responsible for the policies and the procedures of the office. Is that right?
The Attorney General is responsible for the policies and the procedures in the office.
He makes the policies and procedures for his own office, does he not?
He at one point approved those. I think these policies and procedures were in place before he became Attorney General.
They were put in place by Greg Abbott. They're policies and procedures created by the holder of the office. They can be modified and changed by the office holder however she or he sees fit. Isn't that true?
I think that's true.
Okay. But here you are telling us all, or trying to suggest to us all, that the Attorney General, the elected Attorney General of the state of Texas, has to get the approval of his staff to enter an outside contract. That's what you're saying, is it not?
What I'm saying is, in addition to having the legislature also sets the parameters of that authority. Part of the job as the staff is to make sure the office is following what the legislature has granted.
In fact, let's see, we know on the first page that Leslie French, the general counsel, she signed off, true?
I see that, yes, sir.
Joshua Godby, he signed off, true?
True.
Ryan Vassar, who wrote the contract, he signed off, right?
Yes.
Michelle Price, the comptroller, that's the woman in charge of the money, she signed off, right?
Yes.
It stopped with Mr. Penley, right?
That is true.
And this outside counsel contract was being done to do the job that Mr. Penley was supposed to be doing. Isn't that true?
You keep asking that question, and I keep telling you I don't have that same view.
Sure. And let's go to, Eric, if we could, page 14011 of the same document. It's the signature page. 14011. And here's the signature page, true?
That appears to be the signature page.
Contract is written where the Attorney General is to sign. Is that right?
Well, what it says, sir, is Attorney General or designee, and I think I said on my direct examination, it was very rare that the Attorney General himself actually signed contracts. Sure. In fact, when the Attorney General did sign a contract, we actually had a special folder envelope that you'd put it in. There were some requirements of some contracts. I think they were things from the feds that they required actually the actual signature of the Attorney General.
Right. There are some things that the Attorney General could not designate. Can you let me finish, please?
Yeah, I apologize. Okay. Yes.
There's some things that he had to sign, right?
There are a few things he had to sign. Usually, I think they were federal requirements.
And most of the time, though, he designated someone to sign on his behalf, right?
Well, again, most of the time, in my experience as first assistant, it was the first assistant.
But that does not mean he cannot sign, does it? Does it?
No.
Okay. Penley had a real problem with hiring Kamek, true?
Penley had a problem with hiring Kamek, correct.
So Penley refused to sign off, and that stopped the process, right?
That's correct.
Are you telling me you did not know that Vassar had drafted a contract? Is that what you're trying to tell us?
What I'm trying to tell you is the best of my recollection, and the best of the recollection is I don't recall that. No, sir.
Certainly at some point you knew, because you talked about conversations you had with the general where he was wondering why Penley wouldn't sign the contract. You knew the contract existed, right?
I knew that they were entertaining the fact of a contract. So I would assume, yes.
Eric, Exhibit 127, Exhibit 34 within that document, please. All right, looking at Exhibit 34 within 127, we see here kind of the DocuSign history, true?
If that's what you say, I don't dispute that. It says DocuSign. They just highlighted that.
One of the good things about DocuSign is you can see exactly when somebody viewed the document. You can see if somebody rejects the document. You can see when they sign the document. Would you agree with that?
I'm seeing this for the first time.
It's common sense, though, is it not?
The document says that. Well, I think we both agreed neither of us are tech people. Eric is highlighting, and I see what that says.
So let's look at Penley's history. Mr. Penley, according to DocuSign and the document that's in evidence, it was sent to him. That is, the Kamek contract was sent to him on September 16th, 2020. Do you see that?
You're going to have to enlarge it for me, sir.
September 16th, 2020, he was sent the document. True?
Yeah, it looks like it's 6:43:14 p.m. Is that what you're referring to?
He didn't view the document until the day y'all sent the text, did he?
I think there's a record. That's what this says, but I know there was an exhibit that he sends an email on September 24th that he attaches or tries to attach the DocuSign. And of course, you can't attach one. It was just the fact that one had been sent to him.
Shows us here that he declined the document at 3:03 p.m. on October 1st. And then he viewed it after he had declined it an hour later. Isn't that what that shows?
The document says what it says. I don't have any knowledge.
And when your position is, I was adamantly against the Attorney General hiring Kamek, right?
I believe Mr. Kamek did not have the type of experience necessary to assist Mr. Penley in the investigation. You compare him to someone like Joe Brown, who had been a U.S. attorney, who had been actually a DA. There's no comparison in experience.
Could he issue subpoenas? Or could he get subpoenas issued?
Could who? Mr.
Kamek?
Brown?
Mr. Kamek.
Well,
did he have the wherewithal to get subpoenas issued?
Well, we know they eventually did with assistance from Mr. Paul's lawyer.
Do you know how those subpoenas were actually? I don't want to talk about what you might have read in the paper. I want to ask you about what you know. Do you know how Mr. Kamek was? Can you let me finish?
Well, you asked me a question.
I'm getting ready to
about
finish
the paper.
Just a second, sir. Do you know specifically how Mr. Kamek got subpoenas issued? Do you know how that process worked?
I do not.
You claimed to the FBI that he appeared in front of the grand jury, didn't you? That's what you told the FBI, didn't you?
I don't think I told that to the FBI.
What we know happened instead is he was assisted by the Travis County DA's office and was sent a subpoena draft with a DocuSign that he DocuSigned.
I think that's a better question directed at the Travis County DA's office, Ms.
So,
Moore.
did you ever bother even to ask how the subpoenas Mr. Kamek sent were issued?
I didn't, because I didn't need to.
Y'all were drafting collectively, you and the other employees or ex-employees were drafting a letter to send to the FBI or the Texas Rangers?
Do you have something to show me?
Do you not recall drafting a letter where y'all were sending drafts back and forth amongst yourselves of a correspondence you were going to send to the authorities?
If you have something to show me, that may refresh my memory.
Let's look at Exhibit 22, please, within the same Exhibit 127. Go to page, the pages aren't numbered, but go to number 4 within the document, please, Eric. Go all the way to the bottom, Eric. It's very difficult to point this out, but it's the sentence starts, the subpoenas sought information that involve financial records at local banks. Bring that. Go to number 4, Eric. I'm sorry, Eric. It's you're 2 pages off. There we go. Eric, just go to the second to last page, please. Second to last page of the document. You were... The sentence starts, I mean, this is something that you guys were collectively drafting, is it not?
I don't know if I've ever seen this, Mr. Busby.
We took it off your computer.
Off my computer?
Well, the computers from the office, yeah. There were multiple drafts that y'all were sending around.
Was it Jeff Mateer's computer? Can you show me that?
Well,
It said at the beginning, you've been jumping around. This is one of the disadvantages.
I know, I'm at disadvantage too because my guy's way over there.
I know, I understand. We both are frustrated with it.
Let me just focus your attention on some language of a draft letter, and then you can tell me whether you wrote it.
Pardon me, everyone. My objection is he doesn't know the source of this. He doesn't believe where it came from. It's totally inappropriate for him to be asked questions about it. To Mr. Busby shows what he came from, so he's satisfied it's something that he knows something about.
I can handle that, Your Honor. Sure.
Can you help straighten that out?
Yes, sir. No doubt. Did you realize that Ryan Bangert, on the behalf of all of you so-called whistleblowers, was drafting a letter to be sent to either the FBI or the Rangers?
I don't have memory of that.
Did he share with you any of the drafts that he created that was ultimately sent to the authorities?
This is very...
You don't remember?
know. I don't remember, sir.
Okay, let me just see if your recollection of the things that were going on. Would you agree with the statement that nothing in the subpoenas sought information that related to the allegations contained in the Travis County complaint, which involved potential criminal conduct by employees of state and federal?
This related to the first one?
Yeah.
Yeah, I mean, again, you're reading from this document.
Yeah. I'm just trying to...
I would ask, again, what I would ask is what you will do. I assume I would ask Mr. Bangert, because I don't recall.
I'm trying to figure out what y'all thought you knew.
Pardon me again. This entire line, Your Honor, is so misleading. If I'm right, and I'll be corrected, I'll be glad to be corrected from wrong. I believe what we have here is an excerpt from the 50-something page OAG report. What this is a self-serving version of their report that he's being asked about, as if it's something that he wrote, and if not, then something that was written by someone else. And he's acting like this was a fact that they did something. He needs to disclose to this witness where this comes from. It's not coming from his computer. He doesn't have any knowledge whether it's coming from anyone else's computer. This entire line is unfair and wrong for the witness. If he tells him where it's coming from and then ask him if it's right, I won't object. But this kind of shooting in the dark is inappropriate.
Your Honor, Mr. Hardin, if he looked at the document, would know that this came from Ryan Bangert's computer, that it was a letter that he was drafting on behalf of all of the so-called whistleblowers. And there are things in the letter that I think is a misconception that they all had collectively, which was they didn't know about the second referral. That's why I'm asking these questions.
And I've said that, Mr. Busby.
Okay. And that's alarmed you. He's sending subpoenas to banks, and it has nothing to do with the first referral, right?
It was one of the things that alarmed us, I think I've said.
Yeah. Is it, may I ask for a predicate for these questions, Your Honor, is this document that he's been asking him from the Attorney General's office's self-serving document they published to the world as to their version of events? If that's where it's from, then I can go to the page of that report and determine that. But this witness needs to know that's what it is, rather than suggesting it came from his computer or somebody else's computer. This did not, I would respectfully suggest.
It's taking up my time, and if he read the documents that's in evidence, this document is in evidence, he knows that it came directly from Ryan Bangert's computer.
He doesn't
and he
know
knows that
thing.
He knows that Ryan Bangert circulated this so they could get their facts right before they sent this correspondence to the authorities. And that's all I ask him is this true that none of you knew about the second referral, and that's why you were all so upset? That's the point. And I think the point's been made.
Let's move on.
Okay.
Your Honor, this document, it looks like this document was prepared by Mr. Brent Webster.
No, geez, come on. You need to look closely at the document. It's very clear, prepared by Ryan Bangert. Now.
All right. It looks like I'm
Are you
corrected.
satisfied now?
It looks like it's two other people, but it is not this man.
Your Honor, I made that clear. It's Ryan Bangert. I've said it 3 times.
Excuse me. You've testified repeatedly, Mr. Busby, that this man knows X. The only way you're going to know what he knows is to ask him questions rather than suggest it was done by somebody else.
Which is
so
what I was
I'm objecting those improper predicate for this question.
Okay, let's just move on.
Sure.
Thank you.
Trying to. Now, do you know who Bailey Molnar is?
Say that again, sir.
Sorry. Do you know who Bailey Molnar is?
Spell the last name.
Molnar. Works at the Travis County District Attorney's Office. I don't want to say she's a clerk, but she does administrative type work.
I don't think I do. Excuse me, sir. I don't think I do.
So you didn't have any role in her assistance with Kamek in issuing subpoenas?
No.
Okay. Now, you had asked, and your lawyer, or the House's lawyer, had complained that, hey, show him the second referral. You'd like to see it, right? You've never seen it.
If you show it to me, I guess I'll.
Exhibit 127, Exhibit 13. Okay. Have you seen this document before?
I'm still reading it, sir. Thank you.
Have you had a chance to read it?
I'm sorry, I don't read. I read fast, but not that fast. That helps. Thank you, Eric.
What we have on the screen here is what has been referred to as the second referral. Would you confirm with me that this document, this referral, was sent from the DA's office of Travis County directly to Mr. Kamek in Houston, Texas on September 23, 2020?
Well, what I confirm is it's dated September 23rd. The address that's listed is not an office of the Attorney General of Texas.
Now, do you know who Don Clemmer is?
Don Clemmer, I do know who Don Clemmer is.
Who is Don Clemmer?
He used to work at the Office of Attorney General before I was there.
Okay.
I believe worked with Adrian McFarland. Actually, he might have been in a deputy position at one time for when Governor Abbott was General Abbott.
I'm asking, okay, sir, do you see how he listens?
Trying to answer your question.
I understand what you're doing. Can you tell me and confirm that at or around September 2020, he worked at the DA's office for Travis County?
I know he worked at the DA's office. I don't know what his position was, but I see that a letter says what his position is.
Yeah, it says Director, Special Prosecutions Division. See that?
I do see that, yes, sir.
And you told us that Clemmer used to work at the AG's office, right?
Before my time, yes.
Right, so you know that the AG's office is not in Houston, Texas, and he would know that too, right? He would know that the Office of Attorney General is not in Houston, Texas, right?
Well, no, we do have an office in Houston. We actually several offices. I just know that address was not one of our offices.
Right, right. So he would know.
Well, you'd have to, obviously you're asking me a question that you know I don't know the answer to, but he would know the answer to.
Sure. Yeah. So rather than sending the referral to Penley or Maxwell, the second referral was sent directly to the outside counsel, Brandon Kamek. Right?
This letter says that. I don't know why that was done.
And you had no idea about this referral until sometime well after this, isn't that right?
That's correct.
Now, who is Lisa Tanner?
Lisa Tanner was it may still be. Lisa Tanner was a prosecutor at the time I was there in the criminal division. You want more? She's one of the key prosecutors for the state of Texas, or was.
Now, on did you ever once? Let me ask it this way: did you ever discuss with Mr. Clemmer outside counsel for the AG's office?
I don't know if I've ever met Mr. Clemmer.
Okay, I'm not asking that. I'm asking whether you discuss via phone, email, anything like that with Mr. Clemmer.
Again, I don't think I've ever had a discussion with Mr. Clemmer.
Okay. Do you know what the subject was of the second referral? Do you know what Mr. Paul was alleging?
No, you'd have to show it to me.
Okay. Do we have the second one? This is in evidence? I'm going to offer into evidence House 168. It's the second criminal complaint filed by Nate Paul.
Any objection?
No objection.
Enter it into evidence.
We don't have a hard copy? No. All right. Eric, go to the second page, please. Next page, please. Go to page 6. All right. And the jury, to the extent they want to look at it, can see in Exhibit House 168 the nature of Nate Paul's complaints. And you didn't know anything about this. That's what you told us.
If you want me to, I
don't want to waste a lot of time on it. I just want to make sure the jurors know that there is a second referral, and it was the genesis of it was Nate Paul complained to the Travis County DA's office.
I mean, if that's what you're saying, obviously the document is what it is. I'm not, absent me sitting and reading it, I'm not able to answer.
It's okay. Now, you told me, I think, that if you're going to hire outside counsel at the AG's office, you need to go through the procedure, right?
Yes, sir.
That it's absolutely essential that if the DA, and you talked about the legislature and the money and the codes and the policy, it all needs to be followed if you are going to hire, that is, the AG's office is going to hire outside counsel, right?
Yes.
That's
to actually hire and execute a contract, you have to go through the process.
right, and that includes getting approval from the comptroller in that process to fund it, doesn't it?
That you have to have money that the legislature has allocated.
And you told us, I think you told us, that that is in place to protect the office.
Yes, in part, yes.
That is in place so things are done above board and on the up and up, right?
Yes.
Let's look at AG Exhibit 368. And go to the second to last page. Now, let's focus on this all together. Given what you told us, given your objections to the elected Attorney General and hiring Mr. Kamek or anybody outside, what we have here is an email from you the day before you resigned to Lacey Mays, where you authorized the use of $50,000 for outside counsel. What is that?
What is it? Mm-hmm. That's what I was talking about exactly. In order to have a contract.
What contract is that for?
It says what it says. We were considering at this point in time whether the agency would enter into an outside counsel contract with Johnny Sutton.
Wait.
In order to do that, can I complete my answer?
Yeah, sure, go ahead.
In order to do that, you have to have funds set aside. You can't just enter into a contract. You have to have the funds set aside. This is part of the process. What would have followed, Mr. Busby, is the full process. But obviously there isn't such a contract because we did not proceed.
Wow, okay, let me make sure I got this. You are the first deputy, first assistant.
Yeah.
I don't mean you any offense,
I know you don't.
You're the first assistant. You're sending an email to Lacey Mays authorizing $50,000 of our taxpayers' money for an outside counsel, Johnny Sutton. Is that right?
That is correct, setting aside those funds in the event we did ultimately enter into a contract, but we did not.
Well, you certainly did. Johnny Sutton's your lawyer right now, isn't he?
He didn't enter into a contract with the agency.
Let me ask you something. Let's be clear. Answer my question to the jury. They may want to know, is Johnny Sutton your lawyer right now?
Johnny Sutton is my personal lawyer.
Is he sitting right over there?
Yep, I see him.
Okay. You tell me what authority you had as first assistant to set aside our taxpayer money to hire an outside counsel. You tell me that.
I had the authority to set aside the funds because the next step in the process would have been to go through the executive approval memo process. And if all of the deputies would have signed off on it and we had made the determination that that was in the best interest of the state to retain Mr. Sutton as counsel.
For who?
For the state.
For what?
Because we were looking into potential crimes that were being committed.
Did you tell your boss that you were allocating $50K for an outside counsel contract?
If he had come to the meeting can I finish? Are you done?
Yeah, I know you're getting excited. Just let me
Well,
finish.
I am, because this is...
Take it easy.
You're trying to misstate things.
Please.
Let's
Did you
settle
tell-
down here. Just answer the question.
I'm sorry, Mr. President.
You know we had to find this forensically. Did you know that?
No, I don't know why. I turned in my computer.
I don't know why either. But let's be clear about what you did. About what you did. A loyal servant, trusted friend.
Yeah, I never got to answer the question.
I'm going to ask it.
Yes and ask. Just wait for the question.
What authority did
My
you...
objection is, if you'll quit the commercials and testifying and just ask the objection, I don't have it. But when he puts all of these kind of accolades in there, that he is just making fun of the witness in his question, I strenuously object. He can ask a simple question, but not with all these commercials from his side of the case.
What's the objection?
My objection is that he has no foundation and basis for asking questions. He is simply harassing the witness by putting a lot of adjectives in there that he thinks serves him. He's not asking a question. He has for about 2 hours testified, and I've been very patient about it. His questions are testimony. They are not questions. That particular one, if we read back, he starts going on all of these little commercials for his point of view, and I object.
Again.
Let's just move on.
Sure, sir. What authority did you have to secretly go behind your boss's back and allocate $50,000 for outside counsel contract? What authority? Who gave you that authority?
I can't answer that question because what you said is absolutely incorrect.
Show me a
First
statute.
off, sir, we asked to meet with the Attorney General on this date. If we'd had a meeting, had he been here, we could have had a discussion. And perhaps Mr. Sutton could have assisted even him at this point.
Let's look at AG Exhibit 361. and go to page 7, Eric. Lacey Mays took your authorization and sent it to the comptroller, right?
I mean, this is part of an email. I don't see the first part of it. Again, I don't think I'm copied on it.
Your Honor, I do not show that this one is in evidence. And it should be taken down on from the screen for the Senate until we find out whether it is.
Sorry? I don't even understand the objection. This is in evidence.
He's saying it's not in evidence. He's saying it's not in evidence at this point.
It is in evidence. We offered it into evidence, and if to the extent that he doesn't know that, we'll offer it again.
Can we see the exhibit number, please?
AG 361.
361. Yeah, okay.
Do you object?
Bring that up.
Yeah, that's what all right, so real briefly, Your Honor, this is not one of those that was agreed. It was provided to us this morning, an amendment to their list, and I don't even think we still have a copy of it, a physical copy of it, and it's not an exhibit that was part of the agreement everybody reached overnight. So the problem is, we don't have a copy of this. I'm sure he's about to bring me one.
Would you provide a copy?
We can get a copy.
It's now been up on the computer as an inadmissible piece of evidence for about 5 minutes.
Yes.
Thank you.
We'll take it down until we resolve this. Just take it down for a moment, not you, off of the computers on the desk.
We offer 361, Your Honor.
Well, we're going to object, and certainly we may change our mind later, but this is actually an excerpt from a forensic report that we've never had disclosed to her. It's never been part of discovery. And quite frankly, the report was generated on September the 14th of 2021, and they have never blank, blank, blank produced it. And now while the witness is on the stand, they start talking to it. In very understated, kind, and gentle terms, this is outrageous. It violates every rule the Senate had about discovery, and you've entered multiple orders, as you know, and as you've mentioned. This is not the way the process is supposed to work. And we do object. It's a forensic report.
They did. You know, Your Honor, you know what's ironic is we got this, we're told, from them. We got this document from them.
Oh, we violates everything.
I mean, I would have mentioned that, Your Honor, if I'd have known it, but I was just told that in my ear. And of course, it's emails between people in the office, including this man here.
I don't think I'm on that email, sir.
The witness, just hold for a moment.
That was a question.
Is it your document, Counselor? From you all?
I can tell you that we, the trial team, have never seen this document and never knew that it was going to be proposed as an exhibit. I will, when you say that they got it from us, I don't know how they got it from us unless the Attorney General, this is produced by the Attorney General's office. This is not produced by us. I don't know, we'd have to look during the break. We can try to do that because I think that's upcoming. I will be glad to inform the court if it turns out that this document was given to us. We will tell you that, but that is still not the way admissibility should be. If they're going to offer an expert report, in any kind of, this should have been disclosed a long time ago.
It's a good time to take a 10-minute break. We've been here for 90 minutes, and you can take a look at it. Thank you.
Thank you, Judge.
I have a couple of jurors still not back, so we'll wait a moment. Mr. Busby, you may resume. I think that mic's not on.
I want to close this loop on these documents. You heard my colleague, Mr. Harden, say that these documents had never been produced to us. We haven't seen these documents. Your Honor, the documents are bait stamped with their bait stamp. They sent the documents to us. And then when we sent our exhibit list back to them, it was sent to Mr. Harden, and I'm told he failed to forward it to the rest of his team. So, you know, I've withstood a few criticisms from Mr. Harden, which is fine. You know, that's his job. But to suggest that he's never seen the document, that we didn't give him the document, and to object to a document that he gave to us, pretty ridiculous. So we would offer into evidence the two documents that we were discussing before the break, just to confirm, AG 368 and AG 361.
If I may, I told the court that I would look into it, and I think I have it. I think I have the sequence right. This was a document that the AG's office produced to us in August, and in compliance with your order, we tried to turn them around many times within 24 hours, certainly as soon as we could. We produced this document, along with a lot of other documents, back in August, so almost 2 months ago. When we produced it, it was produced in mass, just like this. It was never listed on their exhibit list, and it was never listed as a proposed list. I'm sure Mr. Busby maybe inadvertently spoke now, I'm sure not deliberately, but he didn't add that when the first time we knew they were going to list it as an exhibit was last night. And the first time we saw it as an exhibit in type was today at noon. That's what led to all this hullabaloo. It is a forensic report for the court to understand that was done back in 21, where the agency, after these people left, went to all their computers and did a forensic report looking for evidence and things. And in this one, this was a forensic report done on the computer of Lacey Mays. And that's the sum total. So he is right in that we produced it to him. He's somewhat misleading in discussing when we got it as an exhibit, and we're on notice it was going to be offered as an exhibit. But now that we've looked at it and all, I'll be glad to waive my objection. We'll be glad to have it be admitted and let the jury look at it and understand what it is.
Thank you. Mr. Harden? Yes, so he doesn't object. You can enter it into the exhibits.
Yes, Your Honor. Thank you. I want to make sure I understand. Put it back on the screen, please. Actually, let's just make sure we focus on what this witness sent. Eric put 368, AG 368, which is now in evidence, that we received. You can see, go to the email sent by this witness. Now, sir, I want to make sure we all understand this. You went to the FBI on September 30th, the day before you sent this email, right?
Yeah, he enlarged it. Can you put the date so I can, I'm sorry. Can we, the Madam Court Reporter keeps telling me that when I look at the document, I don't speak into the mic, and so I'll try to be deliberate. Yes, it is dated. It looks like if this date is correct, is October 1st, 2020.
Listen to my question.
Yes.
You sent this email the day after you went to the FBI, isn't that right?
You know, now that I see that day, that time, there's no way Jeff Mateer is up at 1:39 a.m.
So you dispute the email that was sent from your email address?
I'm not, no, sir. What I'm saying is it has a date stamp on it with a time stamp that there's no way I sent it on that at that time. I'm not disputing that I sent an email.
On that date?
I think that date or the day before, the timing could be somehow screwed up on the computer. I don't know.
Let's make sure we have a clean record and everybody knows what was going on. You went to the FBI. You reported what you claimed to be crimes. And then you told one of your subordinates to allocate $50,000 for a lawyer. Isn't that right?
To set aside unobligated reserves in the event we did enter into an outside counsel contract, and the we being the agency.
And you did that. This lawyer, Mr. Sutton, who represents you now, was supposed to be helping Ken Paxton some way?
Potentially, we wanted to meet with Mr. Paxton on October 1st.
With a lawyer?
No, it was going to be just the deputies first, but perhaps that could have led to that had he met with us.
Mm-hmm. So you wanted a lawyer to meet with you with the AG? I'm trying to figure out, why are you using state monies for a lawyer for your personal use?
I wasn't, and I didn't, and I wouldn't.
I guess from your point of view, it's okay to step outside of the procedure when you want to hire an outside lawyer, but it's not okay for the elected attorney general to do so. Is that right?
That's absolutely false.
Now, are letters sent by the Attorney General of the state of Texas official documents?
Yes.
They are official documents, are they not?
I believe so.
Let's all be clear. According to the former first assistant, your position is that letters sent from the AG's office are in fact official documents, correct?
They're documents from the office, and they would be, depending the subject matter, I believe so.
Are you familiar with Texas Penal Code 37.01?
You've got it on the screen.
Let's look at it. Let's bring it up where we can see it, Eric. Can we have it bigger, Eric? There we go. Now scroll it where we can read it. Tell me if I get this right. A person violates 37.10A when he knowingly makes a false record in or false alteration of a government record. Did I read that right?
You read the document, yes?
Before I showed it to you and read it to you, were you familiar with that particular provision of the Texas Penal Code?
Sitting here, perhaps, I don't know.
Exhibit 127, Exhibit 19, please, Eric. All right. What we have here is a letter sent on the same day you guys went to the FBI by your subordinate, Mark Penley, correct?
That appears to be a letter September 30th to Mr. Kamek from Mark Penley, correct?
Who altered this government record?
I don't follow you.
What?
I don't follow you. I don't think this document was altered.
Do you see the letterhead that this letter was sent from?
I see the seal of the Attorney General on it, yes.
Do you see the Attorney General's name?
I do not.
Who removed it?
I don't know.
Would you ever countenance that?
I'd have to know the circumstances.
Well, these are the circumstances. It's September 2020, and your subordinate is sending a letter, an official letter from the AG's office, and he removes your boss's name. Would you ever countenance that?
Again, we'd have to ask Mr. Penley.
I'm asking, would you ever countenance that?
I don't know. In this situation, I don't think this letter was altered because it does have the seal.
Would you authorize that? Would you authorize removing the duly elected Attorney General's name from official correspondence? Would you authorize that?
Again, I don't know if that's required or not.
Would you do it yourself?
I am anticipating that you're going to show me a document.
I am indeed. My question is, would you have done it yourself?
I don't know if Mr. Penley focused on that. I don't know if I focused on it. We obviously we don't print out the letters. They're brought to us and we sign them.
Yeah. Somebody, this is not a situation. I mean, this is an official letterhead of the office. Somebody had to do whatever it takes to remove the duly elected Attorney General's name from the official letterhead. Isn't that right?
I don't know what the process would involve.
Exhibit 30 within 127, Eric. Last page. Nope. There you go. Do you see that on the same day you were allocating $50,000 for Johnny Sutton, you were also sending a letter to Brandon Kamek?
Again, we discussed what we did with regard to Mr. Sutton. I do see that I sent a letter or signed a letter on October 1st, 2020, sent via.
You signed an official correspondence from the Attorney General's office of the state of Texas that had his name removed. Isn't that right?
That's what this shows. I did not focus on that at the time.
Who gave you the authority to do that? Who gave you the authority? Someone that you've already admitted have never run for office, have never gotten a vote, the authority to alter the official letterhead of the Attorney General's office.
I mean, as I mentioned to you, Mr. Busby, I didn't do that. I signed a letter.
Well, who did it in the office? That somebody had to be working for you because you told us you control the day-to-day activities of the office, remember?
I don't know who did it.
And it was just an oversight on your part that you were signing a letter that had your boss's name removed? Is that your testimony to these jurors?
My testimony is that is not something I would have been focused on October 1st.
You were involved in staging a coup, weren't you?
Absolutely not.
That's what you were up to.
Absolutely.
That's the reason you went to the governor's office. That's the reason you were talking to TLR. That's the reason that you had or engaged in conduct removing your boss's name. You were staging a coup, weren't you?
Absolutely not.
The MIDI Foundation, we saw that you signed off on that, right?
We reviewed documents that I approved the investigation and I approved the intervention, correct, sir?
You remember you talked about you came back from vacation and that you found out that a legal opinion had been issued. Remember saying all that?
About the foreclosure?
Do you remember saying?
I'm asking for clarification,
Yes, sir.
Is it about the foreclosure letter?
Yes, sir.
Yes, I remember.
You called it a legal opinion, didn't you?
If that's what the record shows, it was a legal opinion. It was done by lawyers, the Office of Attorney General, under, I believe, the disaster authority.
In fact, Eric, put on the screen, please, Article 2 of the impeachment articles. All right, I just want to, for the sake of clarity, one of the charges in this case is that General Paxton misused his official power to issue written legal opinions under subchapter C, Chapter 402 Government Code. Do you see that?
I see what you've read, yes.
Now, let's look at the legal opinion that has been referred to. Go to Exhibit 12741, Eric. Before we turn the page, why don't we look at the official letterhead of the Attorney General's office? You see it there?
I see, yes.
Of course, that's not the letterhead that you used on October 1st, is it?
No, the two documents are...
You altered it, didn't you? Or you had it altered?
No, sir.
Mm-hmm. But focusing on Article 2 of the impeachment articles, go to the second page, Eric. Actually, third page. It's the last page, Eric. There we go. Would you do me the favor of reading the very last sentence in that paragraph?
Okay.
Please read it loud so our jurors can hear you.
Again, please note this letter is not a formal Attorney General opinion under Section 402.042 of the Texas Government Code.
It's pretty clear, is it not, that this letter does not fall under legal opinions as defined in 402.042, correct?
Well, Mr. Bangert says what it says. It's not a formal Attorney General opinion.
Right, but the article of impeachment says it is. And you know, as a lawyer, it fails. Right there, dismissed, right?
I don't know that.
Well, I mean, you allege, hey, you violated, you did something wrong, you issued an opinion under 402.042, and it takes us literally 20 seconds to show that's not true. That fails, right?
I don't know what you're asking me.
It's like almost like somebody read the first 2 pages but failed to read the last page when they drafted these articles, isn't it?
You're asking me to speculate concerning...
How many foreclosures did this letter stop?
I don't know.
None. Did you know that?
I don't know.
Now, grand jury subpoenas are supposed to be secret? Is that right? How does that work? Do you know?
I don't know.
Okay. Are you supposed to, would it be appropriate for somebody in your office to send issued grand jury subpoenas, copies of them, to some sort of outside lawyer who's not involved in the case?
I think it depends on the circumstances.
Was it appropriate to send the grand jury subpoenas that Mr. Kamek had issued to Johnny Sutton?
I believe in this circumstance it was.
Was Johnny Sutton the office's lawyer at that point when that was done?
Johnny Sutton was never the office's lawyer.
Okay. Was he your lawyer when that was done?
What date was it done on, sir?
Exhibit 35 of 127, Eric. Wait a minute. Hold up, Eric. Let me make sure I got it right. Let me just, before I grab the document, when would it ever be appropriate for either you or any of your subordinates to send grand jury subpoenas or copies of them to some outside lawyer who had not been hired yet?
Object to the form. That's a misstatement. He doesn't know. He doesn't know when he'd been hired.
Well, let's figure that out. If you're asking me, I'll ask him. We were told previously that, you can't know when he was hired, so let's figure it out now. When did you hire Johnny Sutton?
I believe we retained him during that last week that I was First Assistant Attorney General.
Whoa.
Personally.
Wait a minute. You're telling us that you hired and retained Johnny Sutton while you were still at the office?
Correct.
And at the same time, you're allocating $50,000 to retain him?
And we make the decision not to do that.
Wait a minute. Okay, help me on this. If this is news, you're saying under oath that while you were an employee of the Attorney General's office, before you resigned, that you had already hired Johnny Sutton. Is that right?
I believe that's so.
What day?
Whenever that first contact was.
He says in his subpoena, trying to quash the subpoena, it was before you went to the FBI.
I think that's correct.
Okay, so now we're all clear. You personally had hired Johnny Sutton, an outside lawyer, in your individual capacity before you went to the FBI. Is that right?
Correct.
And at the same time, in fact, the next day on October 1, you were telling Lacey Mays and the controller to set aside $50,000 for Johnny Sutton?
For the office to retain Johnny Sutton.
You were going to have Johnny Sutton represent you individually and also the office, and you were going to have the office pay for it?
No, that sounds correct. I mean, it is not uncommon.
You realize now what you just testified to?
Could you let him finish, please? Just finish his answer.
Do you realize what you just testified to?
No, sir.
You just told this entire jury that you had hired an outside lawyer in your individual capacity before you went to the FBI on September 30th, 2020. And the very next day, you were instructing your subordinates to set aside $50,000 for Johnny Sutton.
And the agency never hired Mr. Sutton. The agency never paid any money to Mr. Sutton. The funds were never used in that way. The decision that we made was the agency not to hire him. That never happened.
The decision we made?
Me and the other folks.
Can you help me understand? I guess you've told me now Johnny Sutton was your individual lawyer while you were still at the office. Was he an individual lawyer in the individual capacities of other of your subordinates?
I believe so.
And so your testimony would be that if your subordinates were sending secret subpoenas that had been issued by the Travis County District Attorney's Office, that they were able to do that because Johnny Sutton was their personal lawyer?
I believe it was done pursuant to a request from the FBI
To send to Johnny Sutton?
to send to Sutton and then to the FBI. That's what I understand.
So the FBI, these subpoenas that everybody's complaining about, at least those folks, were sent to the FBI 3 years ago. Nothing's happened so far, right?
I don't know if nothing has happened.
Are you here testifying in any way that Nate Paul had anything to do financially with the renovations of Angela and Ken Paxton's home?
I only know what I've been told.
Told by who? Again, you mean Rylander and Wicker?
Remember, I testified before lunch about that, sir.
Okay, did you ever make any effort to confirm that what you had been told by one of those two was correct?
I did not.
Okay, you just believed it.
I believe Mr. Wicker and Mr. Rylander are truthful people.
Did they ever look at the invoices?
You'd have to ask them, sir.
I will. Okay. I'm asking you. Did you ever look at
I never asked them if they looked at the invoices.
Okay. Do you have any evidence whatsoever, other than what somebody, and you're not sure which one, told you that Nate Paul had anything financially to do with the renovation of the Paxton's home?
Did you say that again? I'm sorry.
Do you have any evidence, to support any allegation that Nate Paul paid for any of the renovations of the Paxton's home?
Other than what we discussed.
Pass the witness.
Mr. Mateer, let's cover a couple of things, hopefully very quickly. Let's talk about this forensic report that he introduced as Attorney General 361. And he talked to you about, I'm sorry, do you want the, Mr. Busby, are these your notes? Mr. Busby.
Mr. Busby?
Mr. Busby,
He's asking if those are your notes.
You want these back? Yeah. Thank you.
And Mr. Harden, please speak up. You're speaking softly.
Thank you very much, Your Honor. I've been mindful of my failings in this regard. Let me ask you this. On Exhibit 361, he talked to you about Lacey May's email that talked about that $50,000, correct?
Yes.
And he made a very big deal, did he not, about the fact that that this was on October the 1st, so that the jury remembers the day that the group of you went to the FBI was what date?
Was the day before, September 30th.
All right. And on the date, the date of October the 10th, is that when you sent the email or text that Mr. Busby asked you about to the Attorney General asking to meet with him?
It's actually October 1st.
That's October 1st.
Yes.
The gathering of all of y'all that we've talked about in that conference room where you found out about the subpoenas was on what date?
That was the 29th.
All right. And on the 29th, I think you described the mood everybody was in and the concerns everybody was. On the 29th, is that when you initially thought and talked about setting aside $50,000 for the group of you to represent Mr. Sutton, the Attorney General's office, as opposed to you as individuals.
Correct.
What was your thinking as to why y'all needed a lawyer for the university, for the Attorney General's office?
Because we were trying to navigate through this with potentially going to law enforcement. And so we wanted someone who had that type of experience at that level.
All right, you knew Mr. Sutton had criminal defense lawyer as well as previous criminal prosecution experience, did you not?
I did.
All right. And each of you, or did all of you know him from past dealings?
Yeah, I didn't know Mr. Sutton very well.
But most of you did.
It did. I knew one of his, I guess, former partners really well, which was John Ratcliffe.
All right. That at sometime that day, did you as a group decide that was not a good idea?
We did eventually decide that, yes.
Was that after you had authorized the exercise of paperwork to make it possible?
Well, what we did again was my email was making sure and seeking confirmation that there were funds in the event we decided to do that. We did not do that. Had we done it, we've gone at length through this executive approval.
Real quickly, if in fact you had decided to follow through on that request that had been put aside, what would you have had to do to get it authorized and done?
We would have had to go through the executive approval memo process, just like we've seen, and everyone would have had to sign off.
And that process would have been necessary before any of the funds would have been expended or even eligible to expend. Is that right?
Before funds are expended or a contract is executed.
All right. So before a contract could have been worked out with Mr. Sutton, you would have had to go through all of that. If you were going to do it on behalf of the agency, you would have to go through all that cumbersome process, correct?
That's correct.
And how long would that have taken ordinarily?
I mean, it can be done within a day or so.
All right. But in the meantime, had each of you decided that you needed to go to law enforcement, and after thinking about different agencies, different possibilities, you settled on the FBI, correct?
That is correct.
DPS had agents that he had been complaining about, correct? That Mr. Paul had.
Yes.
And so in the other agencies that had law enforcement people had been involved, such as the district attorney's office, correct?
Correct.
Objections. Your Honor, I'm sorry.
That's true. I withdraw it. Let me move on.
I mean, multiple leading questions. I just wish he would just ask a
All right,
question.
multiple on a single. My
Rephrase.
problem is, if he just says objection and gives his basis and stops, it doesn't get charged in my time. But we've now had a bunch of time where these kind of speeches have eaten us up. I'll come to you at the end of my statements. I'll withdraw the statement and proceed.
Thank you. And in fairness, both of you have kind of elaborated a little bit on objection, so let's continue. But I will watch it very carefully on both sides.
Yes, thank you very much. Now, if I could, would you please tell me when it was in this process y'all decided to go to the FBI and hire Mr. Sutton personally on y'all's behalf rather than the agency?
We initially contacted Mr. Sutton on the 29th. We reached the decision that the agency doesn't need to contract with Mr. Sutton later on the 1st.
So was there ever any attempt to get $50,000 from the agency, to use $50,000 from the agency, or follow up at all on authorization?
We never started the memo process at all, which was essential to do that.
Are you aware, when we're talking about computer time and everything, of universal time?
Say that again.
Are you aware of universal time?
Now that you say it, I am, the concept.
I want to just get a note if I can. Do you recall Mr. Busby spending a great deal of time with you on both the Lacey Mays email or the attachment to the forensic report and suggesting that it was at 1:39 on October the 1st.
I mean, the document says that. I see.
Does it come any surprise to you that if you go on the internet and check out what universal time is, which is what this was, it would have been at 8:39 the day before, not on October 1st?
That makes sense.
If what I have just said to you is true and accurate, would that have meant that y'all were still talking about authorizing the money on the day, on the 30th, as opposed to the October the 1st, as Mr. Busby was saying?
Yes, sir.
And regardless, when you went to the FBI on the 30th, did Mr. Sutton accompany you?
I believe so.
All right. And by that time, had y'all orally retained him to represent you individually instead of the company, the agency?
Yes, sir.
Do you have any evidence or knowledge at all that Mr. Sutton even knew that y'all had originally talked about retaining him for the agency?
I had no discussions with him.
Okay. So would it be consistent with your level of knowledge that Mr. Sutton would not even have known that y'all had talked originally about hiring him on behalf of the agency?
Based on my knowledge, that's correct.
All right. And then finally, he asked you about this one issue. He asked you about some grand jury subpoenas. At the time that the grand jury subpoenas were shared with Mr. Sutton, was he your lawyer?
Yes.
And was he representing y'all individually?
Yes.
What is your position as to whether anybody who thinks they may have a problem or need a lawyer can share the evidence or the information they're concerned about with their lawyer?
I think you can share information with your lawyer.
And did any of you give any alleged grand jury subpoenas to Mr. Sutton before you had retained him?
I did not.
Okay. Now, I want you ask, when you go to the FBI, just a couple more areas. I believe you said you have no criminal law experience. Is that correct?
When I was at Carrington Coleman, Mr. Coleman made us all take a couple criminal cases. So when I was a first or second year associate, I actually did do a couple criminal cases.
But other than that, what is your experience? If one is reporting a crime, what they believe may be a crime, to law enforcement, do they wait till they're able to establish beyond a reasonable doubt before they report the possibility of a crime?
I don't think that's what you do.
When you went to the FBI, did you go with them to express your concerns and hope that they would look into it?
We just wanted to tell them what was going on.
Did you make any determination as any kind of expert on criminal law as to whether things were or were not a crime?
Not at that time, no, sir.
All right. Finally, on this area, regardless of whether it's a crime, what is your position as whether you were concerned about two particular areas specifically? Whether or not what Mr. Paxton had been doing and authorized and loosened on the world was an abuse of office. Did you have any thought about whether it was an actual specific crime for this or not? What was your thought process?
I thought I had a belief that it was.
Would you still have that belief even if it turned out this or that individual thing was not a crime?
That was based all upon what I knew at that time.
What do you mean?
Well, we knew what we knew. I mean, knowledge on that date. Therefore, based upon the actions that I discussed with you earlier today.
What was your view as to whether or not, if the Attorney General's office, when its own internal people believed the incident at issue was not a crime, if they did not, and it should not be investigated and should not be opened to the file, if your own internal people felt that way, for then somebody on behalf of the office be hired to go out and use grand jury subpoenas to punish the enemies of a friend or a donor, did you have a position whether that it was a crime or not? Did you have a position of whether that was an abuse of the office of the Attorney General?
Objection, Your Honor. That was 3 questions, and it was all 3 of them were leading.
I believe he can answer each.
Sustained.
I'm sorry. Excuse me. Sustained.
Sustained. Yeah.
Thank you, Judge. Did you have an opinion as to what your really hardcore belief was as to that conduct that you believed he had engaged in, as to how that complied with the oath of the Attorney General of the state of Texas?
Yeah, I believe that it violated the oath
Why?
because he was taking actions not on behalf of the state of Texas, but on behalf of one individual.
Against?
He was aligning against other parties, in this, against law enforcement.
Did you have an opinion one way or the other whether he was, by what he was doing, it was interfering with federal and state investigations, criminal investigations?
That appeared to be the case.
Okay. Finally, if you signed on, you authorized the intervention in June of 2020 into the Mitty Foundation case against Mr. Paul's companies, correct?
I did, yes.
If you knew then what you knew now, would you ever have authorized intervention?
I would not have.
That's all I have.
Recross, Mr. Busby?
Yes, Your Honor. You told us all that it was against the charity and for Nate Paul. That's what you said? The intervention?
The intervention was to intervene into that lawsuit. Yes, sir.
No. You told us, in response to the leading questions of Mr. Hardin, that the intervention was against the charity and for Nate Paul. Isn't that what you said?
I think what I meant to say, if I said that, and I'm not so sure I did, it was to intervene into the lawsuit between the two parties, and then there was also, as you know, an investigation into the charity.
So it wasn't against the charity, was it?
It was to intervene into the lawsuit.
Yeah. It wasn't against anybody. It was an intervention, wasn't it?
The intervention was an intervention.
It was an intervention that you authorized,
On
right?
June 8th, that's correct.
And you also authorized an investigation, didn't you?
I believe on the same day or about the same day, yes.
And the impeachment articles, pull it up, please, Article 1. Let's look at it. Paxton caused employees of his office to intervene in a lawsuit. You see that language?
I do, sir.
He didn't cause anything. That's something that each of the people on the executive action memorandum approved. Isn't that right?
We'd ask those people who on that memo.
Yeah. I'm asking you. You're on the memo. You approved it.
I did approve it.
Okay. So this article is hogwash, isn't it?
I think we would need more information.
And you were telling us, that those timestamps in these documents that were given to our side, at least by Mr. Hardin's office, you're saying those were universal time?
Again, I was reading the document like we all were.
Wait a minute. I'm just asking about what Mr. Hardin, the back and forth you had with Mr. Hardin. He asked you about universal time, remember?
Showed a document that had the reference to universal time.
Okay, and you were telling us that universal time, that these documents would not have been 1:30 in the morning, but would have been 8:30 prior? Or you don't know?
What I know is it is very extremely unlikely that I was looking at any email at 1:30. Now, 4 a.m., 9:30 p.m., yes. 1:30, I don't think so.
Well, let's real quick. I believe it was 368, AG 368, if my memory serves. And let's go to the authorization email, so that members of the jury are clear about what you were up to. Can you tell us whether you had already retained Johnny Sutton at the time you sent this email to Lacey Mays?
I would need to know the conversion to the universal time.
Well, I'm not asking about that. I'm asking in your memory. We know for a fact you told us before you went to the FBI on September 30th that you met or talked to Johnny Sutton, that you retained him, right?
That is correct, sir.
Okay. Can we agree that you had retained Johnny Sutton individually before you went to the FBI?
Yes.
And can we agree that after that, according to you, and your story is now, y'all were also thinking about hiring Johnny Sutton for the office itself, right?
We were, yes.
Wouldn't that be a conflict? How the devil is Johnny Sutton going to represent you in your individual capacity and also represent the Attorney General's office when the actual client in the Attorney General's office would be the Attorney General himself?
That's why we wanted to meet with the Attorney General, among other matters, on October 1st.
You're telling this jury, all public servants, all elected, that you thought it was okay for you to hire some outside lawyer in your individual capacity and to also even discuss the office might hire him as well? You think that's okay?
I think it can be okay, yes, sir.
Would you at least agree it wouldn't be okay to have Johnny Sutton be paid for by the Texas taxpayers for your individual representation?
Yes.
That would be a crime, wouldn't it?
I don't know if it's a crime, but it didn't happen.
It didn't happen because you resigned.
No, we made the decision not to hire him by the agency.
Told us how, all this stuff was done for Nate Paul. Remember talking about all that?
We discussed Nate Paul, yes.
And you know for a fact that Nate Paul was a pain in the butt, wasn't he?
I think that's fair to say.
He was a pain. He was a constituent that wanted action, right?
He certainly emailed a lot of people in the office.
I said in the opening statement, when he said jump, he wanted you to jump and just hope you jumped high enough, right?
I think we've examined his contact with me.
You've heard the term, the squeaky wheel gets the grease.
I do know that one.
Sometimes there's in constituent services, there's somebody who's a real pain who is over and over and over demanding action. And sometimes there ain't a whole lot you can do for them. Isn't that right?
That does happen, yes, sir.
Yeah. That's how Nate Paul was. Isn't that right?
He was more than that.
Yeah. He sent letter after letter after letter after letter making threats and accusations to the AG's office, didn't he?
He did, through his lawyer and himself.
Yeah, email after email. He was incredibly unhappy with the action of the AG's office, wasn't he?
I believe at times he was, yes.
He was madder than a hornet's nest at times at the AG's office for what he called incompetence and failing to act. Isn't that right?
The best source of that would be ask Mr. Paul.
Yeah. And this is true because he sent you all of his correspondence that he had been sending to Josh Godby, accusing Josh Godby of having a conflict. Remember that?
I don't know if he sent me all his correspondence, but he did send me correspondence.
He claimed the AG's office had a conflict because the spouse of the receiver in the case worked at the AG's office, right?
If you have it, I could look at it.
Yeah.
I don't.
And he thought that was the reason Josh Godby wasn't doing anything because Godby had a conflict. Isn't that right?
If you could show me the documents, I could look at it.
Well, he sent them all to you. Don't you remember? We looked at them in your direct.
We didn't look at all of them, sir.
Okay. Let's look at AG Exhibit 219, Eric. I'm just going to hit the high points. This is an email Nate Paul sent to you in July of 2020 where he was very upset, very frustrated with the AG's office. Do you recall receiving this email?
1 second, sir. It appears to be familiar, yes, sir.
He says, these emails started a month ago and continue to be ignored. See that part? First paragraph, last sentence.
I'm looking. That's what it says, sir.
Go to the next page, Eric. He's sending you a ton of different emails that he sent to Josh Godby. Here it is where he tells Josh was your direct subordinate or one level below you?
No, Josh would have reported to the deputy for civil litigation.
Which was?
Darren McCarty.
Okay, so this would have been you, McCarty, Josh Godby.
Yes.
Okay.
With an associate deputy to McCarty there as well.
Here he tells Josh Godby point blank, you've exhibited highly unprofessional behavior. You see that?
Yes, I said you've read that.
He says, your relationship with Greg Milligan, that was the receiver in the Mitty Foundation case, wasn't it?
I don't know.
Well, we all know. He says, your relationship with Greg Milligan and opposing counsels has clearly affected your ability to be neutral. You see that language?
I see the language.
He's accusing, yes, sir.
Excuse me, this has not been admitted into evidence yet, I believe.
219 is not in evidence? Your Honor, we offer 219, just to make it fast.
Any objection? Continue.
Thank you, Your
It's
Honor.
admitted to evidence.
Thank you, Your Honor. Looking at he accused the AG's office of having a conflict of interest, didn't he?
Did you read that?
Yes, sir, I did. Clearly affected your ability to be neutral. That's called conflict of interest, is it not?
It says not to be neutral. That could lead to a conflict of interest.
I'm just trying to figure out how Nate Paul had the keys, as we've been told, to the AG's office when he keeps haranguing the AG's office for failing to do its job. Any answer to that?
Any answer to that? He certainly.
Let me go to this.
Would you like me to answer or no? No?
You can answer. If you have an answer as to how we are being sold this bill of goods, that the AG's office had been handed over to Nate Paul, yet we see the real-time correspondence where he's haranguing the office over and over and eventually haranguing you. You see that, right?
Now, can he answer the question, Your Honor? Please.
Thank you, Your Honor. Let's take a look so we can end this up. Exhibit.
Your Honor, I asked those last questions then. Objections to be stricken from the record. He asked this question. He gave a speech. If one looks at exactly what he did with his answer there, the witness asked if he could answer. Do you want me to answer? And then he gives his speech about, well, if you can do so-and-so. And then he withdraws the question. So he's made a speech and testified and not allowed the witness to answer. I respectfully ask that that last question be struck and he be allowed to answer the question before that.
I'll withdraw it, Your Honor. It's fine.
I'll bet.
Finally, Eric, let's look at Exhibit 127, Exhibit 40. What does a litigation hold? What does that mean in the parlance of lawyering?
Well, what it means is when you either send or receive one, it's to not delete anything.
Does that include text?
It includes any correspondence that's relevant to the subject of the request.
Now, would you agree, I mean, you've been a lawyer for 26, 27 years?
Actually longer.
Okay.
I was licensed in 1990.
Okay.
So I think that means I'm 33 years.
33 years.
Yes, sir.
Okay. You know, as a member of our profession, that when you send a litigation hold letter, that means preserve everything related. I may be suing you, right?
That is true.
Did you know that Nate Paul's lawyer sent that to the AG's office?
Yeah, on October 11th, 2020.
Yeah, so 9 days after you left, Nate Paul is threatening to sue the office for inaction, for having a conflict, etc. Isn't that true?
I mean, this is a letter that's sent to Mr. Webster and Mr. Paxton. I'm not at the office any longer. I can read it if you have it.
That's fine, sir. Your Honor, with that, I pass witness.
Ready for the next witness, Your Honor.
Witness is excused.
May this witness be excused, and of course, stay available if there has to be some recall, but certainly not around.
You're excused, but subject to recall. You may step down.
Thank you, Your Honor. Your Honor, we call Mr. Ryan Bangert.
To both parties and the jurors, I plan to go to about 6:30 this evening, depending where we hit a point. It may be a little earlier, a few minutes later, since we started a little late this morning working on other issues. We'll take a break, members, a snack break here for everyone in about another 30 minutes. Okay. OSSO.
I may want to try to do it. If that's okay. If that's okay. Cool.
Members, we're not on a break. We're just waiting for the other witness to come in. Just want to let you know. But feel free to stand and stretch.
Thank you.
Mr. Bangert, come forward. I need to swear you in. Raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth. So help me God. Thank you.
Good afternoon.
Good afternoon.
State your name, please.
Ryan Lee Bangert.
All right. Mr. Bangert, I want, if you will, to keep in mind a couple of things. The way you're positioned is perfect for the microphone, I think, in every respect. You don't have to take your hands down. And if you think I am not very, if I've moved to go out inadvertently, I want you to call me on it and vice versa, okay?
That's fair.
How old a man are you?
I am 46 years old.
And you might want to be a little closer. to the microphone, but see if you can, I think you can bend it towards your face. It might work out a little better. All right, thank you. Where do you live?
I live in Bee Cave, Texas.
So could you take us through, try about a minute and a half, sort of your own personal background, where you grew up, your parents, et cetera?
Certainly. I was born in a small farm town in Illinois called Quincy, Illinois, about an hour north of St. Louis on the Mississippi River.
What did your parents do?
My father's a salesman. He did not complete college. My mother is a school teacher.
And do you recall, what size town was this, by the way?
40,000, give or take.
And that's a little bit bigger than my 9,000 in North Carolina, so 40,000 we considered a big city. Let me ask you this. When you finished high school, where did you go to college?
Certainly. I moved to Fort Worth, Texas when I was in second grade and did grade school there, high school in Omaha, Nebraska, and then I went to Oral Roberts University for college, which is in Tulsa, Oklahoma.
And then what about law school?
I graduated ORU in 1999 and started law school at SMU in 2001, and in the intervening 2 years, I successfully pursued my wife, who agreed to marry me.
And where did you finish in your class?
At SMU?
Yes.
I was first in my class at the law school.
And where did you go from there?
From 2004 to 05, I clerked for Judge Patrick Higginbotham on the Fifth Circuit Court of Appeals.
And after that, in 2005, and let me stop you there. You would have been approximately what? What age by the time you finished clerking for the Fifth Circuit?
About 28, maybe 20. I was 28 years old.
Had you picked, by that time, had you also been involved in Republican politics or other outside activities?
I had been at Oral Roberts University. I had been the student body president, but I'd also been an officer in the college Republicans. I had interned for a Republican congressman on Capitol Hill named John Christensen from Omaha, Nebraska. I'd also served on his campaign. I'd been an intern for a group called the Christian Coalition. I'm not sure if they exist anymore, but I was an intern for them back in the late 90s. I also was a Blackstone Fellow in law school.
What is a Blackstone Fellow?
The Blackstone Fellowship is a summer fellowship program that is administered by Alliance Defending Freedom. And we collect what we would say are the best and the brightest conservative, faith-based law students in the country. And we train them for about 2.5 to 3 months in originalism, textualism, natural law. We give them excellent access to internships, and we also commission them as fellows.
Mr. Banger, tell me this. What role has your religion played in your life, both as a student and as an adult?
Very significant. It's
In what
the basis for everything that I do.
And has that always been true, or is that later in life?
It's always been true. And of course, as anyone would tell you who's been a believer most of their life, you have your ups and downs, but certainly it has been the guiding star in everything that I do.
You're aware, or you're not, of the allegations that have been made publicly, and indeed by Attorney General Paxton and others similarly involved from his point of view, defenders of his, that this is somehow, this impeachment process itself is somehow in the hands and caused by outside groups that do not share conservative values. You're aware of that?
I have heard about that, yes.
All right. Would you please tell us and give me an idea of, for instance, your political philosophy, in the sense if we're on a scale of 1 to 10, and 1 is very, very, very far left, and 10 is very, very, very far right, where do you fit in?
Well, I don't think anyone would have ever accused me of being far left. In newspaper articles describing me leading up to this trial, I was described as working for an extreme conservative group. I believe I work for what I would call a Christian legal advocacy organization, but my politics are very much conservative. My party affiliation has been and always will be Republican, and I have long been associated with what I would call the conservative legal movement. That includes the Federalist Society, the Philadelphia Society, and of course the Blackstone Fellowship.
So if someone would refer to you as a rhino, what is your reaction?
That would be remarkable. and I can't imagine that having any basis in reality.
What are you presently doing? What is your present job?
I presently am the the senior vice president for strategic initiatives and advisor to the president for a group called Alliance Defending Freedom.
Called what?
Called Alliance Defending Freedom.
And the Alliance Defending Freedom is what?
We are a global legal advocacy organization. We specialize in defending religious freedom, freedom of speech, life. We also work very closely on campus with groups who are having their free speech stifled by universities. We also support parental rights. I think that it's fair to say that if you were to put us on a political spectrum, we would be conservative very much, although we are a nonpartisan organization.
At the time, the jury has just heard for several hours from Mr. Mateer. How long have you known him?
I've known Jeff for quite a while. I knew him back when he was at First Liberty Institute prior to joining the Attorney General's office. And I did several cases with First Liberty Institute as a volunteer attorney when I was practicing law at Baker Botts, which I don't think we've talked about, me joining Baker Botts. But when I was there, I was a volunteer attorney for First Liberty.
Yes, when you left law school at SMU, and then after you left clerking for Judge Higginbotham, what did you do?
In 2005, in the fall, I joined Baker Botts in Dallas, Texas. I was an associate there until 2013, I believe, when I made partner as a litigation partner. I was there as a partner until 2016. Right after the election of President Trump, I received requests that I consider joining in the government. At the time, we weren't in a position life stage-wise to go to Washington, D.C., and so I was asked by then Attorney General Josh Hawley to join his administration in Columbia, Missouri. And we had some back and forth, but he's a very persuasive guy.
So when you joined him, what position did you have with Josh Hawley?
I was the deputy for civil litigation, so I ran all the civil litigation in Missouri.
And what was his position?
Josh Hawley was the Attorney General for the state of Missouri.
And of course, since has gone on to other things.
He has. He ran for and won the U.S. Senate seat in Missouri over Claire McCaskill while I was there.
Can we safely concede that Senator Josh Hawley is a very conservative man?
He's a very principled, conservative man.
And how long did you work for him in the capacity as Chief of Staff?
I was 2 years, and I was the deputy for civil litigation.
I'm sorry. Did you obviously end up being offered another job before you left?
I was spoken to by the incoming Attorney General, Eric Schmidt, about potentially joining his administration. Incidentally, Mr. Schmidt is now the junior senator from the state of Missouri. But during that time period, immediately after the 2018 election, when Josh had won the Senate seat and General Paxton had won re-election, Jeff Mateer and I were texting back and forth, and Jeff said, "I think it's time for you to come home."
Did you do so?
I did. I know Brantley Starr, who was a friend of mine and at the time was the deputy first assistant in the office, had been nominated by President Trump to become a federal judge. And Jeff recruited me because we knew Brantley was going to be leaving.
Could you imagine how anybody could be legitimately contending you and Mr. Mateer and the team that was put together at the Attorney General? How could anyone reasonably, legitimately contend that you guys were some kind of ultra-liberal force that was designed to take over and thwart the true conservative mission?
Assumes facts, not in evidence and relevance, Your Honor.
I'm sorry. I'm simply asking you about it. Can you imagine how anybody could take that position? I thought I was taking a shortcut to bringing in evidence on it. All right.
It would be fantasy, pure and simple.
All right. Now, let me ask you, when you left and came back, did you come to work then for the Attorney General's office?
I did. In January of 19, I joined the Attorney General's Office of Texas as the Deputy for Legal Counsel.
And what were your duties as the Deputy of Legal Counsel, and what month did you come back?
January of 2019.
All right. And what were your duties? What did you oversee starting in January of 19?
The Deputy for Legal Counsel oversees a number of different functions within the office. Open Records is one of them. The Opinion Committee is another. The Public Finance Division is another. The General Counsel Division is another. And I was also tasked with overseeing a group called Special Litigation. Special Litigation is a strategic litigation unit within the AG's office that both brings and defends strategic key litigation on behalf of the state.
Now, let me ask you, do you recall the first time you might have ever become aware of a Mr. Nate Paul?
I do.
When was that?
It was either at the end of December of 2019 or early in January of 2020.
Was he on your, the evidence is clear in here that on August the 14th of 19, he had a search warrant executed by a combined state and federal task force at his house and businesses. Did you happen to notice any publicity or anything about that in August of 19?
No.
All right. What was the occasion for you becoming aware of Mr. Nate Paul in either December or January of December 19th or January of 20?
The Attorney General spoke to me about an open records file that he wanted me to take a look into. I also contemporaneously received an email from Jeff Mateer to the same effect.
All right. And did you talk to Mr. Mateer about it, or he just forwarded you the request?
He forwarded me the request. I cannot recall whether I spoke with him or not, but I certainly spoke with the Attorney General.
What was the nature of the request that he referred to you to consider?
The request was basically it was called a reconsideration, a recon, of a previously issued open records decision that had been issued by the Open Records Division.
Had you ever before been involved in Missouri or any other, working with an open records request?
My time in Missouri, I was primarily responsible for litigation, so my experience with open records requests in Missouri was relatively limited. But by the time that this came about, I'd been working with it for over a year here in Texas.
Would you briefly describe for the jury the open records process as it is handled by the Attorney General's office?
Certainly, and I'll do my best to summarize. The Attorney General's office is responsible for ruling on requests by agencies or state governmental bodies who have received open records requests from citizens and who wish to withhold information based on an open records exemption or an exception. And the Attorney General's office will evaluate those requests and then rule on them through a series of letter rulings. We receive thousands upon thousands of these requests every single year. It's all handled through the Open Records Division. They're handled by a team of attorneys who specialize in open records law. And they are, let's just say that it is a well-oiled machine.
And what are we talking about when we say the law enforcement exception?
Yes, there are a number of exceptions in the open records provisions in Texas law. The law enforcement exception is one of those. It's designed to protect law enforcement when an ongoing investigation is taking place against having the defendant or other interested parties procuring information from law enforcement that would disrupt the investigation or potentially compromise witnesses or compromise safety, quite frankly, of those involved.
Does it matter whether the law enforcement agency is a federal or state or local law enforcement agency?
The rules apply slightly differently. The rules are designed for state law enforcement agencies, but we do, as a matter of comity, when there's a FOIA exception for federal law enforcement agencies, honor those requests as well.
But it is essentially a state statute designed, is it not, to regulate or respond to requests that would invoke local or state law enforcement, correct?
Yes.
But if something is to affect, say, if FBI is one of the agencies in a particular event, is it designed to address that as well?
It does.
How does it do that?
We have a number of open records rulings that we've issued, and you'll have to forgive me if I forget the numbers of them. It's been a while. But we effectively agree to honor requests posed by FBI or other federal law enforcement agencies to withhold information, oftentimes information that has been provided to state partners in the conduct of joint law enforcement activities.
So if there was a joint law enforcement operation to involve like 4 different law enforcement agencies, could be FBI, could be DPS, could be local police departments, it could be some regulatory agencies that have law enforcement capability and involvement. If in any of all those situations, Does the AG's office treat that as a law enforcement exception agency?
It's law enforcement exception specifically with respect to state law enforcement agencies, and we'll treat that as a matter of comity, a law enforcement exception for the federal agencies as well.
All right, let's take the incidents that you said you were not aware of at the time it occurred involving Mr. Nate Paul. And among the agencies that were involved there were people from the Securities Board, all right,
Correct.
State agency, from the DPS, state agency, and also the FBI. Would any of those agencies be treated differently?
Functionally, no. No, they would not.
And what does that mean functionally?
It means that the analysis in the open records rulings differed slightly with respect to the agencies, but the outcome was always the same. We would not force those agencies to disclose law enforcement materials that were subject to the exception in the Texas Code for Texas agencies or FOIA for federal agencies. We would allow them to withhold that information. And I also want to point out these requests that were going to, the open records requests, were being posed to Texas law enforcement agencies.
All right. So a private citizen wants to complain about some matter in a search warrant or whatever. What would they do, and how would the process prefer? So let's say a private citizen and his lawyer want to get behind a joint operation by law enforcement and file a Freedom of Information request. How would that proceed?
Same as every other request. The request would go to a Texas agency or a Texas law enforcement agency. They would then submit a request for a ruling to the Open Records Division. And when the law enforcement exception applied, which in these types of cases where there are joint law enforcement activities taking place and they're ongoing, we would almost always withhold the information.
So if, in the example I cited, Law Enforcement Capability Board, Securities Board had people present, DPS had people present, FBI had people present conducting it, how would you proceed with each of those agencies?
The agency making the request to withhold would brief the issue. Interested agencies would then receive an opportunity to submit their own briefs.
Let me start here. If the request went to the Securities Board, what would be the process then, if the first request went to the Securities Board?
The State Securities Board would, if they wish to withhold information under the state law enforcement exception, the Securities Board would submit a request for a ruling to the Attorney General's Office Open Record Division. That request would then be adjudicated by our attorneys. And sometimes there was additional briefing. If there's a party who was seeking the information who wanted to brief the issue, they would submit briefs and we would rule upon it.
All right. And then what would you do about if there were other agencies that had information in there? And obviously, if the request originally went to the Securities Board, would there be possibly information there from DPS and from the FBI? How do you handle that in letting them know whether they can weigh in?
They're notified of the pending request and given an opportunity to brief.
They would be notified as well?
Yes.
So would you notify then each law enforcement agency of the request, even if it just went to one of them?
Typically, yes.
Okay. Now, in this particular time in December of 19, January of 20, would you describe for the jury how you got involved in what you did and what the request was that you were asked to look at by Mr. Mateer?
Certainly. There had been a request made, I believe it was to the State Securities Board, for information relating to the law enforcement actions taken against Nate Paul, concerning Nate Paul. And there were a number of different pieces of information and documents that were requested. I did speak with the attorney for Nate Paul.
Do you recall who that was?
It was someone at the Meadows Collier firm in Dallas.
Something in the Chuck Meadows firm in Dallas?
Yes, Chuck Meadows firm in Dallas. I had dealings with them before on other matters when I was at Baker Botts.
So you already knew the firm?
I did.
All right. So what did you do?
I spoke with them to understand the contours of their motion for reconsideration. Based on my review of the record and through conversations, it became apparent that the thing that was most concerning to the Meadows Collier's firm was getting access to a particular document known as a probable cause affidavit. This is the affidavit that would have supported the search warrant of Mr. Paul's home. There were multiple warrants.
And did you discover whether or not that affidavit was actually under a federal seal in San Antonio?
I did, and I learned that it was under federal seal, yes.
And I'm not sure, you mentioned it there, I'm not sure we were clear before this. The actual event that gets to you, was that the first time the AG's office had been involved in this request, or were you being asked to reconsider a previous decision?
It's the latter. We were being asked to reconsider a ruling we had already made, finding that the documents should not be disclosed, and that includes the probable cause affidavit, should not be disclosed.
And do you recall whether the previous one had whether the FBI had weighed in on it as well, or was it declined initially without even hearing from the FBI?
I do not recall because I wasn't involved specifically. That would have been a routine matter, and the denial of the granting of those exceptions and the refusal to force disclosure would have been routine. It was unexceptional.
Was there anything unusual about the decision you were reviewing in terms of its actual decision itself, namely that the law enforcement exception dictated that the information would not be revealed?
No,
was there anything?
When I reviewed the decision, it was unremarkable to me. It appeared to me to be a straight application of our existing precedent.
And what did you do when you looked at it? What's the first thing you did?
Well, I reviewed it. I understood that there was a motion for reconsideration pending, so I also took that issue to Justin Gordon. Justin was at the time the head of the Open Records Division and was one of my direct reports. I asked him to pull the file, to look at it, to evaluate the decision, and make sure that we had covered all our bases, because the motion for reconsideration, we did get those from time to time. They were almost in all cases denied out of hand.
Yeah, I was going to ask you that next. And in all the cases you touched or watched while you were there, how would you rank the number of occasions in which the law enforcement exception was not adhered to?
Difficult to quantify, but it was been a very unusual thing for a straight application of that exception not to be granted. In fact, I don't know if we ever did it.
So it would be accurate to say that you don't know of one that you had encountered?
I'm not personally aware of a situation where that exception applied where we would not have granted it.
Did you look into Mr. Paul at all yourself?
Say again?
Did you do any research on Mr. Paul?
I did.
What'd you do?
I Googled him.
The ultimate research tool.
Right.
And how did that impact your view?
It made me very concerned that I had been asked to, well, let me back up. I learned through my Google research that Mr. Paul had indeed been, his home and several properties been searched by the FBI, that he was under active investigation by federal law enforcement. And as someone who is a senior staff member, that immediately sends up red flags when you're being asked to review a file for reconsideration to disclose law enforcement materials to someone who is under an active and very far-reaching investigation.
Tell me what the danger is, or what the policy position was in your agency in terms of why would you want to adhere to this sort of rigid rule that if it involves ongoing investigation, criminal investigations, you would cite the law enforcement exception? What's the reason for that?
The policy reasons. There are a number of policy reasons for that.
Don't get too far away from the microphone.
Oh, my apologies.
It's okay.
Certainly, there are a number of policy reasons for that. One of which is you would not want to compromise in any way an ongoing criminal investigation, particularly by state agencies, by releasing information that could cause that investigation to be not able to go forward. More importantly, you also don't want to compromise the safety or the identity of potential witnesses or the safety and identity of those who might be conducting the investigation. So there's both a public policy interest in ensuring the integrity of our law enforcement activities here in the state. There's also a public policy interest in ensuring the safety of those who are undertaking those activities or serving as witnesses.
I was about to ask you, those files, how would you rank whether or not, how often they have actual personal data with people who have cooperated with law enforcement or citizens who have given information but want to remain anonymous as much as they can, the names of people that are involved? How would you describe the potential risks of them if this information started being revealed to whomever was curious, whether it was media or the offender themselves?
Objection to relevance, Your Honor. I mean, it's not with regard to a specific document here.
I'm
It's an
sorry,
overly
repeat
broad
your
question.
objection. I couldn't hear you clearly.
It's an overly broad question, Your Honor, and doesn't specify what specific document that the witness is going to be referring to.
My question is, I'm asking him what the danger and the policies of these things, which goes directly to why they were going to be concerned about releasing this information to Mr. Paul.
Well, I think Mr. Bangert's already answered that question, Judge.
I'm sorry.
I would say that Mr. Bangert's already answered that question.
Overruled.
Thank you.
Could you state the question one more time, Mr. Harden?
Yes. My question is, I'm asking what is the danger and the policy of these things, which goes directly to why they were going to be concerned about releasing this information to Mr. Paul?
Again, safety concerns are paramount. You never want to compromise the identity or the safety of witnesses. And certainly, when I was reviewing files, and I only reviewed files that had what you might call hair on them, or files, in this instance, that didn't have hair on it, but at the request of the Attorney General. There were files where witness identity, sex crime victims in particular, might be revealed. Those were always very concerning. We want to make sure those were properly dealt with.
Yeah. Mr. Banger, do your decisions when you were making these open records requests, if you're not careful about how you do it, are you ever concerned about your setting a precedent that would even be worse than the individual case you're looking at?
Precedent is very important to the Open Records Division. We want to be rigorous in ensuring consistency to the utmost. We want to ensure that as we apply the law, it is applied evenly and consistently for all Texans.
Well, then, if in fact you released the information that Mr. Paul and his attorneys were seeking, that would have given you, what kind of information would that have given them, the person under investigation?
I was very deeply concerned, in particular, about what it would have done to our precedent to overrule the law enforcement exception applied in this case being the reconsideration motion I was asked to review by the Attorney General, because there was a probable cause affidavit in play. Not only that, a probable cause affidavit subject to a federal seal that was part of an active, ongoing, multi-agency investigation. That would have been, in my view, a very poor precedent for us to set and would have disrupted law enforcement activities in the state of Texas.
Did it include what we commonly call offense reports, in which identifying data of the officers and the witnesses were included?
I'm not familiar with that term, but certainly...
Forget the officer. Let me give you, excuse me for interrupting. Let me see if I can give you another term. Would it have included memos about what happened and by whom and who did what, so that personal identifying data would be in there about law enforcement and anybody else, witnesses?
Certainly, law enforcement exception covers documents that contain personally identifying information for law enforcement and witnesses.
And would that file, that would also include the names and addresses potentially of victims
Objection
or
to improper
witnesses?
foundation, Your Honor. This witness hasn't.
Excuse
He
me.
hadn't laid the foundation to establish he has knowledge of the file.
I'm simply asking him what all is there that they're trying to protect.
Overruled.
Thank you.
There's a whole panoply of information that could be included within documents covered by the law enforcement exception.
So when this was over, well, let me ask you this. During your deliberations about this matter in January of 2020, did you have any contact with the Attorney General about it?
I did.
And what was the nature of that? When, where,
Certainly.
how, what?
Initially, the Attorney General asked me to review the motion for reconsideration. Unusual in the sense that he typically did not involve himself in open records requests, but he is the Attorney General, and I certainly wanted to honor and fulfill that request, so I reviewed it carefully, and I very quickly reached the conclusion that the decision was correct, and I advised him of such.
Let me go back for a moment. When you were hired, did you ultimately, though I believe you said that you were recruited by Mr. Mateer, but did you have contact with the Attorney General and meet with him before you were hired?
I had, not before I was hired, but I had had contact with the Attorney General going all the way back to 2014 when I was a partner at Baker Botts. I contributed to his campaign. I supported him during his primary campaign, I believe, was against Mr. Branch. I believe I was the only partner at Baker Botts who did so, so I was told. But I believed in what he was doing. I believed his policies were the best for Texas. That's why I joined his office in 2019. I believed in what he was doing. I also believed Texas was leading the way in representing the interests of the conservative legal movement here in the U.S.
So would you characterize yourself as a strong supporter?
At that time, yes, I was. That's why I joined the office over other opportunities that came my way.
So in addition to this reconsideration request on the Paul case coming from the lawyers for Mr. Paul, where in that scheme of things did the Attorney General reach out to you as well and ask you to look at it?
Again, it would have been toward the end of December or beginning of January, either 19 or 20. He asked me to take a look at it. I did. I reviewed it, came to the conclusion that it was correct. Typically, in instances like that, the Attorney General would say, "Thank you for that review," and we would move on. This was different, and it struck me.
How was it different?
He pushed back, and he pushed back not necessarily by contesting my application of law, but by saying it doesn't seem fair to me that a defendant should not have access to something like a probable cause affidavit, something that's being used to investigate him.
Was there any conversation? Well, that would be a consideration for the judge and courts that were involved that he should go to, or tell me about any conversation or response you had.
There was federal case law on that point, and I shared that with the Meadows Collier firm, pointed out to them that all they needed to do was go to the federal courts and file motions with the federal judge. And if they were denied, they could go to the Fifth Circuit. And there was good case law there too. And I shared those facts with the Attorney General as well. There was a federal option.
What was Attorney General Paxton's response?
The Attorney General shared with me his view that he had been wronged by law enforcement and was uninterested in having other Texas citizens wronged by law enforcement as well.
Did he express to you any further, as far back as January of 20, his views of law enforcement?
He was clearly very skeptical of law enforcement when we were having those conversations. I was surprised by the level of pushback I got to what I viewed as a routine application of the law, but we continued to have those conversations with him all the same.
Well, once you made your view known, and once he pushed back, did you have any further conversations with him?
We had a series of conversations.
About this subject?
About this subject in January.
Excuse me, about this case as well?
We had a series of conversations about this specific open records request, the one for reconsideration of the SSB request, yes.
The one on behalf of Mr. Paul?
Yes.
How many times would you estimate that you had conversations with the Attorney General in which he was urging you, or was he, in these conversations, was he urging you to take a particular position?
He was certainly applying pressure to look for any way possible to disclose the probable cause affidavit. He did not instruct me to override or overrule our existing precedent at that time, but he was very interested in finding any way he could to have that probable cause affidavit released.
And what was your reaction?
I told him that that would not be a good idea.
So ultimately, was it disclosed at that time?
It was not disclosed at that time, to my knowledge, no.
How did the issue end? I mean, how did you move away from it?
I think we may have just worn each other out on that, but he
You what?
did.
I'm
We
sorry.
may have just worn each other out on that, but he did eventually. And of course, remember, we're now ramping up into COVID in 2020. February and March was the beginning and the explosion of COVID. So other events began to overtake the office very quickly.
And actually, in February, as early as February of the COVID year, 2020, before everything really breaks out the middle of March, did you yourself give talks and research and conclude it was going to be a huge issue, particularly as it affected the legal things that the AG's office was going to have to get involved in?
Yes, we, even before March, when COVID became a reality for most Americans, we were wargaming, planning, having internal meetings about what the potential legal effect would be if a pandemic were declared and COVID hit our state.
Did the Attorney General's office have a position from the very beginning, initiated and urged by the Attorney General, as to what y'all's legal position was going to be in dealing with the COVID plague, in the issues of whether it's masks or whether it's meetings, whether it's gatherings, whether it's activities? What was his position that each of you were challenged to carry out?
Yes. The situation was very fluid in March. I would say we didn't have a position per se, but very quickly over time, as states began shutting down, canceling school, mask mandates were imposed, stay-at-home orders were imposed. Very quickly, it became the policy of our office, and I would argue the policy of the state of Texas, to do everything we could to keep things open as much as humanly possible, consistent with public safety.
Counselor, I went a little past our break, I promise, for everyone involved. Is this fine?
This is fine. This is perfect.
We'll break till 20 after, take a little bit, it's a 20-minute break, 10 after, 20-minute break, 10 minutes after, 20-minute break, get a snack, and then we'll go to about 6:30. We'll go another hour when we come back.
Thank you, Your Honor.
Yeah, I think so. Very hard to hear. I can't hear at all. Could you hear him back there? I can't tell if I can hear or not. My dad and his wife said they could hear him on TV. Like, I couldn't hear what he's saying. No, I won't. And I've got, as soon as I ask 10 questions, I'm going to be fine. Yeah. I just haven't spoken yet in this trial. I've got to enter a few of these. I'm debating whether to go ahead and just like get with them about it, or I could just enter them as I go.
Just go, just do it in the normal way. Just offer and admit, offer and admit.
One copy of it.
This one copy? You're not going to need it. They're not going to object to anything. Did you watch how Tony did it? He just brings it up. They're not going to bitch.
Speak loud. I'll pull it up. I'll get right up. Testing. There we go. Okay. I appreciate that. No, I'll speak up. And you're not going to report it. Oh, okay. Okay. I can speak up. Right. Yeah. I'll speak up. Let me see. Let me get my. Right there. Yeah, we're good. Testing. Okay. I won't stand up.